Ask staff to please hand out the bill packets to members. We have Senate File 3735 before us. Senator Hoffman, our chief author, is present. Welcome to the Judiciary Committee. Senator Hoffman, would you please go ahead and describe your bill?
Mr. Chair and members, there's 3575 and there's 4235. So would you like to hear the 3575 one first? Is that the right?
That's the correct one, please.
Awesome. Good morning, members, Chair and members of the Judiciary and Public Safety Committee. Senate File 3575 increases the penalties for imposing a peace officer in Minnesota. As said by the Minnesota Police and Peace Officers Association, the Minnesota Chiefs of Police Association, and the Minnesota Sheriff's Association in their letter of support of this bill, Minnesotans expect and deserve absolute confidence when an individual presents themselves visually or verbally as a police officer. That person is a duly licensed Minnesota peace officer. This bill helps reinforce trust in legitimate law enforcement officers in our state and sends a clear signal to people that they will face stiff and severe consequences if they violate that trust. It is simply unheard of that if somebody is imitating our most trusted safety person in the state of Minnesota, Mr. Chair, that right now it's a simple misdemeanor. I was almost killed. My wife was almost killed. And my daughter had a gun faced in her face by an individual who looked like a police officer, had a vehicle that looked like a police vehicle, yelled, "This is police," had his license plate that said police on it, was wearing everything that you would think a police officer is. But you know what, Mr. Chair, he was not a police officer. But thank God for the real police officers who were first to come to my house. As I lay on the floor in my kitchen and my wife lay next to me, and the EMTs that came with them, they saved our life and got us to the hospital. Real, legit police officers. So, Mr. Chair, not only does this make sense policy-wise, but personally, I usually don't bring my personal stuff into politics, but in this case, Mr. Chair, I urge you to support this important legislation. I do know that Senator Limmer, if he has it, has an amendment that needs to go on with the chiefs of police and somebody else. There were some technical changes that were made. And I'm also, Mike Ledoux, who is one of our partners in this whole process, one of our retired state troopers who protected me when I was in the ICU and protected me and my family in our house. So, Mr. Chair, I offer, I don't know if it's the A3 amendment. I can't offer it, but the good senator from Maple Grove, it's the A3 amendment. Senator from Maple Grove sure can.
Senator Hoffman, we have the A1 amendment before us. Members, this will be an author's amendment. Senator Limmer moves adoption of the A1 author's amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Lieutenant, no.
Trooper Mike.
Whatever your position is right now, Mr. Ledoux.
Mr. Chair, members of the committee, my name is Mike Ledoux. I'm the Director of Legislative Affairs for Law Enforcement Labor Services, and I served as a Minnesota State Patrol Trooper for 31 years, including serving as President of the Minnesota State Patrol Troopers Association. Thank you, Senator Hoffman, for bringing this bill forward and for your leadership on this issue. I'm here on behalf of Law Enforcement Labor Services, representing more than 8,800 law enforcement officers and public safety professionals across Minnesota, to express our strong support for Senate File 3735. This bill has broad support across the law enforcement community because it addresses a basic but critical issue. Public safety depends on trust that is immediate and unquestioned. When someone presents themselves as a peace officer, people rely on that in real time. If that trust is compromised, it can create confusion, increase risk, and make already dangerous situations worse. Impersonating a peace officer is not a minor offense. It is a misuse of authority that can be used to facilitate serious and sometimes violent crimes, while also undermining the legitimacy of those who serve. The events of June 14th, 25 had a profound effect on the state and on those of us in law enforcement. We continue to think about the loss suffered by the Hoffman family and about Senator Hoffman and his wife Yvette as they recover. What was especially troubling to many of us in the profession was the use of the police disguise in carrying out these crimes. That kind of deception doesn't just enable violence, it undermines the public trust in legitimate law enforcement. Senate File 3735 takes a clear and practical step forward. It strengthens penalties and reinforces the integrity of legitimate law enforcement. Mr. Chair and members, we respectfully ask for your support.
Thanks, Mike.
Thank you, Mr. Ledoux, and we're obviously very, very grateful. Senator Hoffman is with us to present this bill. Any member questions or discussion? Senator Westlin.
I will in fact be brief, just to say thank you for bringing this bill. I'm sorry for the reason why you had to bring the bill. I'm just glad you're here.
Thank you.
Any other member discussion? Senator Limmer moves that Senate File 3735 as amended be recommended to pass and be referred to the Senate Committee on Finance, as there are some very small tails they'll have to figure out. All those in favor say aye. Aye. Opposed? The motion prevails. Thank you, Senator Hoffman.
Thank you,
Don't go anywhere.
Mr.
We
Chair.
have your other bill, too. Senate File 4235.
Thank you, Mr. Chair and members. The other thing that was a part of what 3735 addresses, Senate File 4235, is the removal requirement of identifying equipment and insignia from emergency vehicles to the public. Senate 4235 prohibits the sale of a public safety vehicle to the public unless any equipment or insignia that could mislead a person into believing the vehicle is a public safety vehicle is removed first. This bill is also about trust. We want to make sure that Minnesotans aren't misled about who's behind the wheel simply because of how a car looks. The misuse of former law enforcement vehicles is a real and growing issue, and we must prevent people from exploiting the look of these vehicles to commit crimes or violate the public trust. There was one incident in the good senator from Maple Grove. The State Patrol had pulled over a vehicle that looked just like a police car, said not the police or something on it, but was pulling people over. And Mr. Chair, this was the fourth time that individual had been pulled over for impersonating police and having a police vehicle, former police vehicle, that looked pretty standard, had the lights, had everything on it. Thank God our state trooper pulled him over, because at that time it became that arrest turned into a felony. Why did it take 4 times for an individual to do that? There's actually a group of individuals that go out buying these cars, and if you look on, I don't know, I'm not under 30, so I don't know the social media reels to look at. I don't know, Mike, you tell me, but there's a, what are the social media reels? There's a group of individuals out there, Mr. Chair, that actually, build this up and they brag about it. So this will protect the public. To this day, if there's a vehicle that looks like a police vehicle and I'm on the road, I'm taking exits and taking lefts and rights to try to avoid that person or that vehicle because I think they might be following me. Think about that for a second. Not okay. This helps prevent confusion about the public safety vehicles on our road, because if I get pulled over and I don't recognize that as an actual legit police officer or a police vehicle, it's not good. Right? We have to be able to be good about this. So this bill really does that next piece of it, Mr. Chair. Thank you.
Thank you, Senator Hoffman. I don't have anyone signed up to testify. Mr. Ledoux, did you wish to testify or just available to answer questions?
I'd be happy to testify and or answer questions, being respectful of the chair's time.
If you have anything to add to what Senator Hoffman has already said, go right ahead.
He said it so eloquently, sir. I don't have much to add other than strong support from the law enforcement community to make sure that these vehicles that are being turned out to the public do not resemble a law enforcement vehicle. It can be a problem. There are a certain group of the population that try to intimidate and impersonate the police, and law enforcement, of course, does not want our profession undermined by people impersonating the police. So strong support again. Appreciate Senator Hoffman bringing it forward, and appreciate the support of the committee.
Thank you, Mr. Ledoux. Any questions? Senator Seeberger.
Thank you, Mr. Chair. Thank you, Senator Hoffman, for bringing this bill. I'll be a yes. In reading through it, is there some prohibition in law already for preventing, for example, a light bar or a siren from being purchased by a member of the general public and converting their own vehicle? I'm thinking, of course, of our neighbor to the east, Wisconsin, allows volunteer firefighters and EMS personnel to equip their own personal vehicles with light bars and sirens. And I'm wondering, I know we don't do that here in Minnesota, but I'm wondering if we have that prohibition against allowing those things to get in the hands of regular folks.
Senator Hoffman.
Mr. Chair and Senator Seeberg, you can go on Facebook Marketplace and purchase a light bar for $150. I mean, it is that easy to get that stuff, right? And the light bars now, they can change the colors, they can do it on it. What woke me up at 2 o'clock in the morning was the light bar in the neighborhood and the pounding on the door. And that light bar should not have been in his hands, right? Just like the individual had 50-some guns. Where's our red flag laws on some? Where's the protection in place? And yet he was claiming to be it was claiming to be a police officer. When you finally see a real police officer in your door, I'll never forget that moment. And every time I see Sergeant Lewis from Champlin Police Department, I start crying. Just like I am now. And you don't ever see this in me. So, no, the answer is no. Am I correct, Trooper?
Mr. Ledoux.
Mr. Chair, committee members, only if the light was activated and used, right? So in other words, you purchase that red light, you put it on the dash, and then it's activated when the law enforcement vehicle. Certainly, I'm not a subject matter expert on all instances regarding lights, but it does have to actually be in use. And there are exceptions in the law for tow trucks and other vehicles under the statutes that govern lighting.
Senator Limmer.
Thank you, Mr. Chair. Mr. Ledoux, there are businesses, security businesses that drive around, they have cars, trucks. They sometimes put an image on the side of their car, kind of resembling a law enforcement image. Maybe they have an outline of a badge or a star, something like that. Would they be prohibited to continue doing that with if this bill is passed?
Mr. Chair, Senator Limmer, I do not believe so, because they're not identifying themselves as a police officer, a deputy, or a state trooper.
Okay.
Any further questions or discussion?
Okay. Thank you.
Not seeing any. Senator Seeberger moves it. Senate File 4235
Go to the floor.
be recommended to pass and be re-referred to the Senate Committee on Transportation. All those in favor say aye.
Aye.
Opposed? Motion prevails. Thank you, Senator Hoffman. Be well.
Thank you, you're a mensch.
Senator Bolden back. Thanks for coming back, Senator Bolden. We're going to continue on the agenda now with the Senator Bolden block of bills. Next up, Senate File 4147. Senator Bolden.
Thank you, Mr. Chair.
I see there are two testifiers. If either of them are present in the room, you can come on forward and take a seat next to Senator Bolden. Go ahead.
Thank you, Mr. Chair. Thank you for having me back.
We had a choice?
Always a choice.
We're glad to have you back, Senator Bowman.
This is a bill, Chair and members, with a state solution to a problem that plagues our democracy, the problem of corporate and dark money in our elections. But this isn't a campaign finance bill, it's a corporations bill, which is why I am here with you today. It's about what powers the state chooses to grant corporations in the first place. This bill is a corporate reset. It simply removes the power of political spending from the bundle of charter powers that the state of Minnesota chooses to grant all legal entities, for example, corporations. But I want to take just a minute to talk about the problem we are trying to solve. The problem of dark money, corporate spending in our elections. Over the last 2 decades, the U.S. has seen an explosion of outside spending in our elections. In 2008, it was $144 million nationally. In 2024, that amount was over $4.5 billion with a B and rising. That's a 2,800% increase since the Citizens United Supreme Court decision unleashed a torrent of dark money and outside spending that has flooded our elections at every level. This is a national problem, but it is also a Minnesota problem. A report from the University of Minnesota Humphrey School of Public Affairs found that over half of spending in the most competitive races in the 2020 elections in Minnesota was dark money. Money where voters couldn't determine who was behind the ads or the spending. In 2024, state elections in Minnesota attracted over $25 million in outside spending, over half of which did not fully disclose the source of their funding. I won't belabor the point, but we have a big problem, and voters across the political spectrum want us to do something about it. Poll after poll, and any given day talking to folks in our districts, show clearly the concern about money in politics, and it is overwhelmingly cuts across party lines. Voters are concerned that wealthy donors' influence is growing. In January of 2026, 68% of those polled say wealthy donors have more influence than a decade ago. And 76% agree that large donors make it harder for ordinary Americans to have their voices heard, including supermajorities of Republicans, Democrats, and independents. A whopping 81% of Americans are concerned about the influence of money in politics, and 77% say it poses a threat to elections. There is very little in our politics that 80% of Americans agree on, but on this issue they do, which makes sense because it is about protecting their power as voters and citizens in our democracy. And the good news is that we can do something about this. States have the power to take action to eliminate corporate and dark money from our politics. Now, I imagine we are going to hear the Chamber of Commerce, the corporate spending lobby, say that there is nothing we can do, that lawmakers and the public are helpless because Citizens United prevents any and all solutions to stem the flood of money and influence into our elections. And you can understand why they would want us to believe that. The Chamber and their big business lobbyists rely on this flood of corporate dark money to get their way and exercise their power in these very halls. But the thing is, that is just not true. States are not powerless. We have always had the power to decide and prescribe what powers, if any, we want to grant corporations to exercise. This is very clear. Citizens United is about whether Congress and the states could regulate powers that states had already granted to states to spend in elections. But this policy is not about regulating the rights of corporations. It is about what powers we choose to grant to corporations in the first place. And the good news is that it is very clear in the Constitution that that is left up to us to determine, state legislatures. Natural people, human beings, are born empowered with rights. Corporations are not born. They are built and exist only as a function of law. For over 2 centuries, the power to define the form, powers, limits, and privileges of corporation belong to states. That's us. And that leads us to this bill. Because we, the state, have the power to define what powers and privileges corporations have and what they don't. It's clear our voters don't want corporations flooding our elections with their cash, and political spending is not a power that we need to grant them. And this bill takes that power and privilege away for all artificial legal entities. It does that by changing Minnesota corporations law to remove the power of legal entities to exercise political spending power. And it requires that all political spending is done so through the political committees set up in Minnesota, where contributions are disclosed and rules apply. I want to be clear that this does not regulate or restrict any rights of natural persons, human beings, acting in their individual capacity. and it does not impact any other powers that Minnesota grants corporations to carry out their lawful purposes. It simply uses our power as a state to refuse to grant corporations political spending powers, making that power beyond the scope of their charter. We might also hear today that this is just not possible, that if we do this, terrible things will happen, the sky will fall. To that, I will just note that we have already lived in a world where this was our reality. This bill will take us back to the election spending environment of 2009, which is not even that long ago. We've lived in this world of excessive dark money spending in our elections for the last 16 years, but we don't have to continue. So whether you love Citizens United or join the 80% of Americans who think it is wrong, it really doesn't matter here. It is very clear that states have the power to determine what powers it grants corporations. The question is, will we use it on behalf of our voters or the corporations who want to outspend them? Thank you, Madam Chair.
Thank you, Senator Bolden. We have a few testifiers. First, we'll go to Tom Moore, who's online. You can unmute and begin your testimony.
Thank you very much. Chair, members of the committee, thank you. My name is Tom Moore. I'm a senior fellow for democracy policy at the Center for American Progress. I've testified before this committee already on SF 4147. You have my written testimony from the earlier hearing, and I'd be delighted to take further questions on it, especially regarding the authority this legislature has to take these steps that are in this bill. But for my testimony today, I'd like to do something a little different. I'd like to speak directly to the Republican members of the committee. Based on what I heard earlier in this committee and on the House side, some lawmakers may consider this bill to be something that just benefits Democrats. This is the rare structural reform that isn't a zero-sum game. It doesn't help Democrats and hurt Republicans or vice versa. This bill makes the system work better for everyone. In the post-Citizens United era, every one of you serves under the threat of a dark money-backed extremist primary challenger. This affects how you govern. It affects whether you can work across the aisle, whether you can take a tough vote, whether you can actually legislate as a body instead of constantly looking over your shoulder. This bill reduces that pressure. It removes that constant, unaccountable threat and gives you more space to do the job your voters sent you to do. Now, I do want to be clear about something. I do have a side here. I am a Democrat. I work for the leading progressive think tank. I'm proud to do so. But this is not a bill that helps my side. In fact, it took a while for my bosses at the Center for American Progress to throw their support behind this approach because there's just about as much dark and corporate money on the progressive side that would be affected by bills like this as there is on the conservative side. In Colorado, I was working with a group of lawmakers who were getting ready to introduce their version of SF 4147. And it was the progressive nonprofit community that freaked out because they had gotten used to operating under the current system for the past 16 years. They've gotten good at raising and spending corporate and dark money, and they don't want to change how they do business. And the backlash was so strong, the lawmakers ended up not introducing the bill at all. You know, as it turns out, getting rid of Citizens United is much more popular when people don't think you're actually going to do it. This bill will do it. I'd like to leave you with one more thought before questions. This bill is about giving the human people of Minnesota more control over their politics. If this bill passes, all political funds spent in Minnesota come from human people, and all of it will be disclosed. A lot of political control has drifted away from the people and into the hands of artificial entities over the years, and the people don't like it. This bill brings control of our political system back in the hands of Republican, Independent, and Democratic voters. Thank you.
Thank you, Mr. Moore. Now Victoria Ford. Is she online as well? We don't see Victoria Ford online or in the room. So the next step is there's an A4 amendment, I understand, in the packet. Is Senator Bolden, is that your initiative?
Yes, Mr. Chair. I would like the A4 amendment.
Go ahead and describe it, please.
Thank you, Mr. Chair. This amendment comes after conversations with the Secretary of State's office in order to make the process more workable for them.
Members, it's a part of your packets that were already distributed. Is there any discussion or any questions about the A4 amendment? Senator Westlin moves adoption of the A4 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Is there any further discussion from members of the committee about anything related to Senate File 4147? Senator Cronin, then Senator Limmer.
Thank you, Mr. Chair. I'm just looking at the fiscal note here. Does this, and I don't know questions for, but does the fiscal note include the attorney's fees that we're going to lose when this law is struck down in court?
Mr. Turner? Senator Cronin, were you asking a question about the fiscal note, or are you addressing a question to a testifier?
Whoever wants to answer the question, Mr. Chair.
Mr. Turner, if you can help answer the question, terrific.
Mr. Chairman, members, I'm just quoting the fiscal note here from the Attorney General's section. The new provisions prohibit certain electioneering activity. The bill could face a legal challenge. If the bill faces a pre-enforcement challenge to its constitutionality, there are potential secondary costs associated with the bill, which are not specified in the above tables. Legal costs can be expected to be at least $300,000, if not more, depending upon the complexity of the case. If a pre-enforcement challenge is successful, the prevailing party's legal fees may need to be paid from the general fund.
Mr. Chair.
Senator Cronin.
Thank you, Mr. Chair, and thank you for that explanation, because the reason I ask it is because the last time the Center for the American Progress brought us a bill here, it ended up costing Minnesota taxpayers $760,000 because the law was struck down in court, just as we said it would be in this committee. And that's how it played out, and we had to take that $760,000 from our general fund, which could have gone to all sorts of different things, because we had to pay the attorney's fees to the prevailing party in that case. Do you have any concerns that we're about to head down the exact same road with this bill?
Senator Bolden.
Thank you, Mr. Chair. Thank you, Senator Cronin. I will say it is certainly possible that if this law, gets passed into law, that it will face a legal challenge. It is the right of folks to do that. In reference to the previous bill you mentioned, that did face a legal challenge, and it was then allowed to continue to have foreign influence corporations spend money in our elections. I will say, my door is open to talk to anyone who wants to propose solutions to this problem. We need to tackle this problem. And because it might face a legal issue, does not mean on the merits that it should not be pursued and that we should not try to do what we can, and is clearly within the law and within our purview as a state to do this. We should be trying to tackle this problem. It is what Minnesotans want us to do.
Any further discussion?
Mr. Chair.
Senator Cronin.
Thank you, Mr. Chair. Well, I'd like to help and collaborate, but I'm not on the United States Supreme Court. So it's going to
Not yet, Senator Cronin. Our resident constitutional expert.
It's not that if this bill were to become law, it may face legal challenges. It will face legal challenges, and we will lose again. And it will cost the taxpayers hundreds of thousands of dollars, if not more, again, to make a political point that this legislature is not able to make. And it's just not a wise use of taxpayer funds. This is an unconstitutional bill. Doesn't matter what the intentions are that you're trying to get at. It's going to get struck down. It's going to cost the taxpayer money.
Senator Limmer.
Thank you, Mr. Chair. Senator Bolden, this bill was presented to this committee as a means to negate Citizens United Supreme Court decision. Can you tell me how a state statute can overturn a Supreme Court decision?
Senator Bolden.
Thank you, Mr. Chair. Thank you, Senator Limmer. It does not overturn a Supreme Court decision. What it does and which is fully within our scope and our role. We, the state, have always had the ability to designate powers to corporations. We decide what powers corporations have, what they can lawfully do or not. That is, corporations are solely an entity of the law. And so we decide that, and we can decide that they don't have the power to spend money in our elections. And that's what this bill does. It removes that power from corporations so they don't have the power to flood money into our elections. It would mean that all money spent in our elections goes through our regulated processes that are transparent. We talked a little bit about that earlier today, have rules and processes and laws and regulations and are transparent. So Minnesotans can know who is spending money, who is paying for ads, who is trying to influence their vote. Right now, we have, as I mentioned, sort of the numbers, $4.5 billion in the last election spent, and much of that is untraceable. We don't know. You know, an ad for, Minnesotans for hot dish, there's no way to trace who is putting money into that. And that matters. Citizens feel that their voices are being drowned out by that of dark money and corporations. And that is harming our democracy. And this is not a partisan issue. It is harmful across the board. And so this is a way that is squarely within our responsibility and ability as a state to determine what power states have and what they don't. And we do not have to give corporations the power to spend money in our elections.
Mr. Chairman.
Senator Limmer.
Thank you. Senator Bolden, I agree with you that the state has the authority to set parameters of play for a corporation in our state, unless the Supreme Court has made an exception. And the Citizens United decision made exactly that. They specified that a corporate donation, let's say to a PAC, is something that is recognized as a First Amendment right. And so I agree with you in general that a state has the authority to govern and set up the rules of play for a corporation. However, Citizens United made that exception. So I think this bill is nothing more than a rhetorical exercise. And I agree with the senator who said, when this gets petitioned in a Supreme Court later on, it's going to be, it will not stand the merit of scrutiny by the Supreme Court.
Any further discussion on the Senate File 4147? Senator Kroon.
Thank you, Mr. Chair. So what I heard you just say is that the legislature can take away this particular constitutional right. And so my question is, if the legislature can take away this constitutional right, well, can we take away other constitutional rights? How about if we passed a law that said that the legislature can take away corporations' Third Amendment right? They'd have to house soldiers without their consent. Could the legislature do that?
Senator Bolden.
Thank you, Mr. Chair. Thank you, Senator Kroon. That's actually not what I said. Corporations don't have constitutional rights. They have powers that we give them. Corporations are not people. And so we do have the ability to decide all of the powers that corporations have. That is our responsibility. And so, yes, we can determine what powers they have and what they don't. And Mr. Chair, I think the testifier would have something to add to this as well, if you would allow.
Mr. Moore.
Thank you very much. I appreciate it. And it's an excellent question. It kind of gets to the nut of all of this. The powers have to come first. In order for something to have the capacity to do something, the state, you guys, have to give them the power to do it. So when your question about the Third Amendment, whether you can keep government from quartering troops in your house, that corporations do have a Third Amendment right, but only because you have given them the right to own property. I'm sorry, excuse me. You've given them the power to own property. And because they have that power to own property, there are certain rights that attach to that. And, the Third Amendment protections are one of them. Fourth Amendment protections are one of them. But the Citizens United right that we speak of, that, corporations have an unlimited right to spend independently in candidate elections, that only has something to attach to with a corporation because you've given them the power to spend in politics. But the court has never said, and I defy any of you to read every word of Citizens United, every word of Bellotti, every word of any case the Supreme Court's ever made. There has never, ever been a case that says the state has to give corporations certain powers. You guys could wipe them off the books tomorrow. You could just erase the corporation code from your statutes. The Supreme Court has, you have given them notice that you could do that because there's a piece of your law that says that. And the Supreme Court has said you have absolute authority to do that. The Supreme Court has never, ever told a state that there's a certain power that they have to give as a matter of federal law. It's just, what the Supreme Court has said over and over and over again is that this is a matter of state law and not federal law. This is the 10th Amendment issue. This is a states' rights issue. I'm a little surprised to see a number of people dismissing so quickly the prerogatives of the states that are defined, given to them in the Constitution. This is the job of the state of Minnesota to define what its artificial entities are, what its corporations are.
Senator Kroon.
Thank you, Mr. Chair. And maybe the reason I'm so suspicious is because when you, as this left-wing organization, came to us the last time with a bill, it cost the taxpayer $760,000. So forgive me if I don't just automatically rely on whatever opinion you are proffering right now. And moving on to the definition.
Senator Kroon,
May I?
merits. Mr. Moore, very
May I address
briefly in
that?
response to that.
Sure, thank you. I appreciate that point. I was not at the Senate American Progress when that came out, but I actually did the initial work on that at the Federal Election Commission, the intellectual work behind that theory that turned into those laws. The difficulty that law has had in a version of it in Maine, especially the version of Minnesota, it still stands in Seattle and a couple other places. The difficulty that courts have had in upholding those led me to this approach that is not regulatory at all. And it doesn't touch campaign finance law. It doesn't do any of that. It does not regulate. Supreme Court, you're right, has walled a lot of that off. But this whole powers end of it, where you guys define the powers, is entirely separate, and it's incredibly strong authority. But the experience that you guys had with losing that case is part of what drove me to develop this strategy. And it is much more powerful than anything on the campaign finance side.
Senator Kroon.
Thank you, Mr. Chair. Getting to subdivision 2 in the definition of legal entity, just cutting straight to the chase here, what does this definition include? Labor unions?
Who's your question
Yes.
directed at?
Chief author, Mr. Chair.
Senator Bolden.
Thank you, Mr. Chair. Thank you for the question. Yes, legal entity, it essentially includes all entities who are not humans. So it would include labor entities, nonprofits, et cetera.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. And can you explain on section 7 of the bill, this non-revival clause? We don't see that. Usually we see a severance kind of language about if part of the bill is struck down, it doesn't strike down the rest of it. What is this non-revival clause and what does that do?
Senator Bolden.
Thank you, Mr. Chair. Thank you, Senator, for the question. So this portion of the bill provides direction to a judge, to a court, that speaks to our intent, and should the bill end up in court.
Mr. Moore, do you have anything to add to that? You sounded like you were about to start speaking.
I was waiting to speak. Thank you, Chair. Yes, it's this kind of clause is not unusual. It's a variety of different kinds of legislation. And basically, when a court strikes down a statute, if it's going to, it has a choice whether to just strike it down entirely and just leave it, or strike it down and reinstate the previous language. If it's a constitutional amendment, you can't do that, but statutes you can. And the choice to add that here is very, very powerful because it says to the court, look, if you want to strike these power grants, you can do that, but don't bring the old ones back. They cannot come back. It is the view of the legislature. They should not come back. And that's a very powerful thing. And I think the idea there is to give the court, make them think twice before they strike a positive power grant, because striking that doesn't fix the problem. It doesn't give anybody more powers. It just takes all the powers away. So it is a strong drafting choice, not an unusual one, but it does a lot of work here.
Any further discussion?
Mr. Chair,
Senator Kroon.
what rights, I'm genuinely confused as to what rights would it not reinstate if the law were to be struck down?
Mr. Moore.
Not rights, it's the previous power grant. You know, the grant that you have right now is basically all powers necessary and convenient to do the entity's business. And the new power grant that the bill proposes is all of that except political spending power. And what the bill says is like, okay, or if you don't like this, if you've got a problem with it, when you strike this down, don't bring back the full power grant that we had before. If you're going to strike it down, you gotta take it down altogether. And part of what it does is it emphasizes to the court that it cannot pick up a pen and write powers into your laws that you didn't put in there. Courts they have an eraser. They can take things away. They do not have a pen. If you've got a list of powers this long that you give corporations and the court says, no, you really ought to have this one, it can't write that. Only you can. If there's a regulation and the court says like, no, you can't regulate in that way, they can just strike it. You can't enforce it. You're done. The status quo is restored. But on this power granting side, it's very, very different. The tools that courts can use are very, very different. And I know it seems unfamiliar because no bills have really addressed this section of your authority or used this part of your authority in a century.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. So when you say if the court strikes this law down, it's going to have to take it down altogether. That was your words, take it down altogether. What does that mean? That there are no grants then of any powers to corporations if the courts strike this down?
No, actually what it does is the court only has jurisdiction if it has a remedy. If literally, if the court can't do anything that actually solves the problem that is the basis of the lawsuit, then they don't have jurisdiction over the matter. And if a court can't, if you were to pass this statute and become a beacon of hope for a lot of people in America, if you pass this statute and a court, for whatever reason, was eyeing looking at that and taking it out, this says like, no, you can't. Striking it is not going to get you where you want to go. Striking it will get you nothing. And so it basically just removes striking that power grant from the kind of remedy that a court actually has available to it. It makes clear to the court that that's not a remedy that's available to it.
Mr. Moore, wouldn't the result of that simply be a reversion to the previous statutory form that existed before the bill became law?
No, it's not, because that's exactly what that language is doing. The language you asked about is the instruction to the court, do not revert to the previous language. And
so we'd be left with nothing?
Well, no, the court wouldn't do it because they don't have a remedy. That's the remedy has to remediate. If the remedy doesn't fix the problem, and striking that your new power grant would not fix the problem, it can't do it. It's basically it's an insurance policy for the new power grant.
Then what does the court do if they think it's not a valid law? But you're saying they don't have a remedy.
It means the plaintiff loses. If the court doesn't have a remedy, and on the regulatory side, the court almost always has a remedy. But on this power granting side, it's very, very different, and it's hard to get your head around. But basically, if the court doesn't have a remedy, the court literally doesn't have jurisdiction to hear the case, and the plaintiff loses. So your law stands, and dark and corporate money are out of Minnesota's politics at the state, local, and federal levels. And if the court can't touch it, the court can't touch it. If they don't have jurisdiction, that's the end of the story as far as the court's concerned.
Wait, so you're saying by including this provision in the bill, it essentially prevents any court from reviewing it? They can't act to invalidate it.
The hope is,
or if they do, we're left with nothing. I know they can't. They can't even act to invalidate it, is what you're saying. That was Senator Kroon's question. What's,
Well, if they can't act to invalidate it, then it stands, and then, the law stands. I mean, which it should, because it doesn't violate a single a Supreme Court precedent over the last 250 years. It stands
Mr.
in the
Moore,
middle of.
I'm struck with the same question Senator Kroon has. You're saying that we'd be passing a law that in effect would make it impossible for a court to review it. So therefore, it would remain in effect. Even if a court
You pass plenty of laws that courts cannot review. If you pass if there's like your budgets, there's plenty of stuff that you guys do in the budget that is just your authority to set the budget for something, and courts can't review that.
But this is not a budget bill.
At the very least, it's not. It's, in fact, you guys have heard of rational basis review and you've heard of strict scrutiny review. There is a level of review that courts use for states when they're setting power to their corporations. It's called the reserved powers doctrine. And I learned about it while working on this project. And it's the easiest standard in the world to meet. The court says, has the state reserved the power to make these changes to its corporate powers? And if the answer is yes, if you have something sitting in your law that doesn't, we're done. That's the only inquiry the court does, because your authority to set the powers for corporations is so broad, weirdly broad, when you compare to everything else that you guys do and all the restraints that you have on you. Your authority to set the powers of your corporations is just about absolute. The court has never said that it's anything but absolute.
So you're saying that
it's hard to. Sorry.
So you're saying the court's only real option would be to say we cannot act in response to this lawsuit because we don't have a remedy.
Yeah, but that's not unusual. I mean, that does happen. Courts all the time say, like, hey, the thing you're asking for, we can't do. So we don't have jurisdiction. The case has to be dismissed. That happens all the time. It's not unusual in litigation.
Thank you. Senator Kroon.
Thank you.
Thank you, Mr. Chair. I guess what I'm hearing is that by including the Section 7 in the bill, we're passing a law that cannot be reviewed by the courts. So I think that's a way that the bill author intends to limit the jurisdiction of the court so the court can't even evaluate constitutional review, which quite frankly sounds absurd to me.
Any further discussion? Not seeing any.
Chair.
Mr. Chair.
Senator Holmstrom, and then Senator Westrom.
Thank you, Mr. Chairman. I guess what I just heard is that let me start with this. Foreign corporations can invest in Minnesota politics per the Supreme Court ruling, correct?
To whom are you directing the question?
Oh,
Senator
I'm sorry,
Holmstrom?
Senator Bolden.
Senator Bolden.
Thank you, Mr. Chair. Senator Holmstrom, I guess I'm not fully understanding your question. Per the Citizens United Supreme Court ruling, is that what you're asking? I don't know that that.
Senator Holmstrom.
When they overruled House File 3.
Senator Bolden.
Senator Chair Latz.
Senator Moore to respond, or Mr. Moore to respond.
I'll start and then Mr. Moore can proceed.
Mr. Moore, do you know what Senator Holmstrom is asking?
I do, thank you. Yeah, I mean, the district court in that case basically said that the particular way that it had been written, did not meet the standards. It did use a strict scrutiny standard on that because it was a regulation of political speech. That's fair. And it said it just didn't meet that standard. It's not that no bill along that line could meet the standard. And they definitely did not say that foreign corporations have an absolute right to spend in Minnesota's politics. That's not the case. But it was the way that particular bill was written, it did not pass strict scrutiny, which is very hard to pass.
Senator Holmstrom.
Senator Bolden, should corporations pay taxes in Minnesota?
Senator Bolden.
Thank you, Mr. Chair. Yes.
Senator Holmstrom.
Thank you, Mr. Chair. So what I'm hearing is that the intent of this bill is to strip corporations away from any federal spending, any election spending, and then also, for an unknown reason, take the power of the courts away from reviewing it. Well, I think we know what the reason is. The reason is because last time it got overruled and you didn't like that, so now it seems like you're just trying to take away power from the court. I don't even know what my question is. This is a totally unserious bill.
Senator Wellstrom. Senator Wellstrom.
Mr. Chair, question for the author.
Yes, sir.
Chair, Senator Bolton.
The author is Senator Bolden.
Excuse me.
Senator Wellstrom, go ahead.
You mentioned earlier in your testimony, this would cover corporations, unions, and others. Just looking at the bill summary, and it lists under the definitions, corporations, partnerships, nonprofits, but it doesn't explicitly call out unions. Where are you getting that language, or can you reaffirm to us that you're talking about everything, every entity that could have dark money or soft money, and not just leaving a loophole here for unions, which are
Senator
big
Bolden.
spenders?
Thank you, Mr. Chair. I'm not sure what summary you're reading, Senator Westrom, but I would direct members to lines 1.9, where the definition of legal entity is listed. Legal entity means an entity whose existence, legal status, or limited liability is conferred by Minnesota law. Legal entity includes, but is not limited to, entity governed by chapters, and then a foreign entity, which in this case is a business that is chartered outside of Minnesota. And so this does include unions as well as nonprofits, corporations, LLCs, any entity that is not a human.
Senator
All right,
Wellstrom.
thank you.
All right. Any further discussion or questions on Senate File 4147? Not seeing any. Senator Westlin moves that Senate File 4147 as amended be recommended to pass and be re-referred to the Senate Committee on State and Local Government. All those in favor say aye. Aye. Opposed? No. Motion prevails. All right, members, we're going to thank you, Senator Bolden.
Thank you.
Does that conclude your day with us today?
No, Mr. Chair. I will be presenting a Senator Mann bill later this evening.
Oh, you are welcome back at any time. All right. Give me a moment. We'll identify the next bill. Senator Champion's bill, Senate File 3665, related to economic development.
Thank you,
Senator
Mr.
Champion, the packet's being distributed. Go ahead and describe your bill.
Thank you so much, Mr. Chair. Thank you to the committee. I know that you all have a long day, so I'm going to try to be as expeditious as possible. Let me give you the backstory around Senate File number 3665. Senate File 3665 is really about safety for deeds, unemployment insurance, and paid leave judges. Safety concerns have always been at issue, but particularly since COVID. UI staff have had more instances of harassing, threatening contacts from people. Some of these instances include a person calling one of our judges at 11 p.m. on their personal cell phone while she was home alone. Another calling another judge on their personal cell phone and revealing details indicating that they know where a person attends the gym. Revealing personal details about a judge on the record during an appeals hearing. Simply what I'm saying is that unemployment insurance and paid leave judges are often in situations where they need to deliver unwelcome news to an applicant based on the law. People may understandably be in challenging circumstances, but threats and harassment are not appropriate responses. So let me tell you what the bill does. If you look at Minnesota Statute Section 480.40, this bill prevents a person, association, or government entity from knowingly publicizing personal information of any judicial official on the internet. This statute also defines, and this bill defines judicial official and includes several different types of judges. Unemployment insurance and paid leave judges are not currently on that list. So this bill would modify that same statute to include both unemployment insurance and paid leave judges under the definition of judicial official. So they may, so that they may receive the privacy protection set out in the rest of the statute. If you look in our bill under subdivision 1C, it lists out what counts as personal information for the statute. Residential address of a judicial official or spouse or domestic partner, or kids, personal phone numbers, names of children, childcare facilities, or schools, just to name some of it. So that's what it does, and that there is an amendment that we have as well. And Mr. Chair, if you're okay, I will have Devin Boundary, who's the Government Relations Director from Deed, sort of walk through the A1 amendment that we hope that this committee will move as well.
Senator Champion, there is only one small amendment contained in the A1 as far as I can tell. Oh, no, I take that back. Well, this is an author's amendment, so, or it's not. The copy of the bill that I have in front of me says it was referred initially to this committee. Senator Champion, is this the first committee to hear the bill?
Yes, in the Senate. Yes,
In the Senate,
Mr. Chair.
That's where we are. All right. So Senator Seeberger moves adoption of the A1 amendment as an author's amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted.
And just for clarity,
Senator
Mr. Chair,
Champion.
the A1 amendment that you just adopted, one, it does two things. It clarifies that the protections only apply to unemployment insurance and paid leave appeals divisions, and two, excludes these teams from the real property protections under 480.50, which is how other agency teams are situated in that statute. So for further clarification and just to make sure I am accurate as it pertains to the A1 amendment, if my testifier can just fill in the blanks there, that would be great.
Mr. Baudry, if you have anything to add, go ahead. If not, that's okay too.
Chair, that covers it.
Thank you. Any questions or discussion for our testifier or among members of the committee? Senator Holmstrom.
Thank you, Chair Latz. Senator Champion, I've been pretty vocal in this committee about my disdain for doxing and for putting this information online. And I guess my question to you is, why stop here? Why not extend it to everybody? Why are we creating a special class of person that for some reason is protected against this heinous crime?
Thank you, Mr. Chair.
Senator Champion.
And thank you, Senator Holmstrom. We've had plenty of discussion about that, and we thought that this was the best approach now, and we want to further look at whether staff should be included and whether there are others that should be included. But this is where where all the allies and other people, judges and others, thought that it would be important for us to start.
Any other questions? Senator Kroon.
Thank you, Mr. Chair. And we've done this for other groups, and I'm just trying to figure out, and I'm looking between the A1 and maybe I'll just ask you the question, does this include the real property records, or was that taken out?
Mr. Baudry.
Chair, that's Senator Kroon. This takes out the real property protections. In speaking with the counties, I understood then that there was a significant cost, and that's not my intention.
Thank you, Mr. Chair.
Senator Limmer.
It was me.
Senator Kroon.
Thank you, Mr. Chair.
Follow-up. Okay.
That saved me a long list of questions that I was about to ask. Thank you.
Any further questions or discussion from members of the committee? I'm not seeing any. Senator Clark moves that Senate File 3665 as amended be recommended to pass and be sent to the Senate floor. All those in favor say aye. Aye. Opposed? Motion prevails.
Thank you, Mr. Chair. Thank you, committee.
Senator Frentz, are you joining us online?
I am, Mr. Chair. Good afternoon.
Are you ready for Senate File 4035?
I am. Thank you, Mr. Chair. Would you like me to present?
Yes, we're going to have the bill packet distributed to members. While that's happening, you can go ahead and start your presentation.
Thank you very much, Mr. Chair and members of the Senate Judiciary Committee. I'm proud to present to you Senate File 4035. This relates to ongoing work in both chambers on homeowners association. This bill is essentially what I consider mostly non-controversial portions of that discussion, best practices, if you will. It allows for transparency, it allows for disclosure, and it's a consumer protection bill. I want to thank my co-author, Senator Kroon, and my testifier will be, I believe, Mr. Carlson. We have protections in there for due process. This means the things that allow members of a homeowners association community to get notice, to understand when fines and delinquencies may affect them, and really, Mr. Chair and members, to prevent the surprise foreclosures that are sometimes, not frequently, sometimes a feature of the homeowners association life, if you will. We also have some additional disclosure obligations for developers. These are contained in the bill, essentially saying the reserve account, that's the amount of money, members, that is set aside to protect homeowners association members in the case of costs, needs, think repairs that are unexpected. Again, Mr. Chair and members, many of these associations are well-run and don't have significant problems in this area. The intention of this bill is to address that relatively small number where we hear stories about assessments that lead to notice issues. Those assessments, members, of course, can cause residents to find out that they're behind the 8 ball. In a housing context, we definitely do not want that. And so the provisions of the bill will allow there to be better protection and still properly balance the rights of the developer with the tenant. With that, Mr. Chair, if you'd like, I can have my testifiers present.
Yes, Senator Frentz, who are your testifiers? I don't have anyone listed specifically other than Mr. Carlson, who is sitting in the testifier table in front of me. Is this your testifier,
I do have Mr.
Senator
Carlson
Frentz?
listed. Yeah, I do have Mr. Carlson, and I'd like to start there. I couldn't see him very well from my tiny little laptop, Mr. Chair.
No problem. Senate needs to issue a bigger laptop. Mr. Carlson, go ahead.
Thank you, Mr. Chair and members. Joel Carlson, and I'm here on behalf of the Greenstein Sellers Law Firm, and Matt Greenstein is probably going to walk through the bill for you if you choose, and I have a couple comments at the end. This is the second CIC bill that you have heard this session, and I don't believe it's controversial. I do want to address a letter that's in the file that I want to address. We've spent a lot of time over the interim working with stakeholder groups to achieve consensus on some areas that we really believe need to happen. And we're here in front of you today, and I appreciate Senator Francis' comments because there are areas that need improvement with this law that hasn't received a significant update in over 30 years. And so we do think there are things that can be improved. And this is one of those potential vehicles. So I'll let Mr. Greenstein take it from there.
Mr. Greenstein.
Thank you, Mr. Chair. The provisions that are being added are non-controversial and based on best practices for HOAs that are operating in Minnesota. Lines 10.24 through 10.28 require that Board of Directors adopt a formal policy for a fine schedule. That fine schedule has to inform all homeowners about what the remedies might be in the event of a violation. And that fine schedule also then is required to be provided to disclosures for potential purchases of properties. And the proposed legislation also updates those disclosure requirements, both the resale disclosure statement that's required to be provided by developers to purchasers and the resale disclosure certificate that's provided by the association to purchasers after it transitions from developer control. Similarly, in lines 14.17 through 14.26, there's an obligation for board members to adopt a collection policy. That collection policy has to provide a minimum of 3 formal notices to homeowners who are delinquent in payment of assessments. One of those notices has to be provided by certified mail. And then there's additional obligations after those notices are provided for any law firm that is performing collection services on behalf of the association. This particular section is something that I've worked with clients on for many years, And I've been informed by clients who've adopted such policies that they've had an 80% reduction in the number of files that are sent to a law firm for collections or foreclosure. So this is based on best practices. It's common sense, and it really does address what is lacking in the statute with respect to what is the due process and what are the notices that are required to be provided prior to a homeowner being sent to collections or potentially an association pursuing a lien foreclosure. Other sections update additional disclosures. One of the big things that has been impacting homeowner associations in recent years is insurance requirements. There's nothing in the current disclosure statutes that advises a purchaser on what type of homeowner's policy needs to be in place to protect them from any type of insurance claim or to pay any kind of loss assessment deductible. And many of the stories and things that came out of the HOA task force that's been working on some of this legislation and some of the issues I've been dealing with clients for years is that homeowners don't have this right insurance in place, and when a claim happens and there is a loss assessment, they're unable to afford that and wind up having to pay out of pocket. So adding some of these important provisions as mandatory requirements in the statute for the board to formally approve and adopt and provide to homeowners, and then adding them as requirements to the disclosure provisions in the statute are all very important. We've worked very hard on getting feedback from other groups involved in this area. We have not heard any negative comments with respect to the language that is in Senate File 4035, and I can answer any questions of the committee.
Thank you, Mr. Greenstein. Members, also handed out to you is a letter from the Legal Services Advocacy Project signed by Ron Elwood, in which he is asking the committee to not pass this bill and outlining the information, the reasons why that they oppose it. Mr. Carlson, have you seen a copy of that letter?
Mr. Chairman and members, yes, I have, and I really want to appreciate my longstanding working relationship with Ron, and in fact, the bill that's before you, we vetted with him and made several changes to it based on his information. But what you need to know is that legal aid does represent a portion of homeowners that live in HOAs, but it's a small percentage. Most of the people that live in common interest communities or have common interest property, like condominiums, car condominiums, or storage condominiums, or office condominiums, are just by definition not represented by legal aid. So there are many more voices that need to be at the table, and contrary to the suggestion that we're bypassing the process, I think getting a bill drafted and working it through the stakeholders and getting it in front of you is the process that we go through, and that's why this bill is here. I also would point out that, well, there is a bill that is moving along and we're working with it. Many of you on this committee didn't support that bill because there's not consensus on that bill yet, and we're going to keep working through that. But to suggest you can't advance a bill like Senator Kroon's, who had a 92-page CIC bill, or this one that can't get added to the conversation, we think that is a step back from the process, not violating it. And so I appreciate all of his comments, but to suggest we can't move forward on a bill where there isn't controversy because someone has controlled the space in one area just doesn't make legislative sense to me. And as was indicated in his letter, they've added 11 of the 13 provisions to their bill already. That is the kind of consensus we're trying to get to. But we're not certain what the path for the other bill will be. We are not at consensus with thousands of HOA board members, attorneys, and others. And so this is just another vehicle to continue the conversation with voices that need to be heard on this issue. And Senator Kroon, I appreciated his bill, and we testified in support of that. I went through this bill line by line with Senator Croon before he agreed to be a co-author of it, because that's the kind of consensus we're trying to bring to this area. We've got 1.5 million people living in common interest communities in Minnesota. I don't think we should have just one voice saying this is what it should be. So that's why we're here, Mr. Chairman. And in all due respect, as he had suggested, I think that's the reason to move the bill forward so that we can continue the conversation.
Senator Pappas.
Thank you, Mr. Chairman. With all due respect to the testifiers and to Senator Friends, I don't think there's been one voice here. I mean, we've had Senator Paz bill, extensive hearings last year. Her partnership with Senator Lucero has been very strong. They've met with lots and lots of people, I'm sure, including yourself. So it's not just Mr. Elwood who has some issues. I just feel like, out of respect for the author, of the original author of the bill, who put so much work into this, I think we should be working with her. And so I will not be supporting this bill today.
Mr. Carlson.
Senator Pappas, I'm not suggesting and don't want to suggest that we have not been working with all of those authors. We have been, and we continue to. Over the interim, working with many of your colleagues, wanting to have a bill that had consensus was very much desired by everybody. That's the work product that you have in front of you. We're not trying to bypass anyone or any author. I've spent hours and hours with Mr. Elwood, Representative Bonner, a little less time with the author of the bill, Senator Lucero. He's left many of the negotiations to Representative Bonner, but we've spent hours and hours and hours with them working through the process. We're not trying to bypass them in any way. That's not our intention at all, and we continue to work with them. So,
Senator Westlin.
I will be brief as well. I appreciate my colleague, Senator Friends. I appreciate the testifiers. I'm also not going to support this bill. This feels to me, my sense is if this gets passed, none of the other things that have been worked on are going to move forward, and I think they're important. And just for the record, I live in an HOA. I've lived in multiple HOAs. I think I'm representative of many people who live in HOAs, and I think there is an attempt to do something a little bit more comprehensive, and I do support those efforts. And if there's work that needs to be done, then it should be done in the bill where hours and hours and hours and hours have gone into it. There's an existing bill. Again, I think if this moves forward, I think the other bill is going to die, and we're never going to see some of the other changes that need to happen. So I, sadly and respectfully, will be a no vote.
Senator Croon.
Thank you, Mr. Chair. And when I evaluate bills like this, I'm looking at policy. And there's just nothing wrong with this bill from a policy standpoint. Everything in here is solid. It's good. It's good policy. And the reality is, if we want to talk about the politics of it, the Senate already passed that other bill. And it's just being held up in the other body. So why would we not try to advance the good parts that are in here, good policy that will help a lot of HOAs provide clarity and strengthen our HOA law, because we want to hold out for something we have no control over in the other body that may or may not pass, that has the controversial provisions in it that do not have consensus. To me, good policy is good policy. It's either good or it's not, and if it's good, we should move forward on what we can move forward, and that other bill will either pass or fail in the other body, and we have no control over that. But what we do have control over is passing good policy in the Senate. So on the merits, we should pass this bill.
Senator Holmstrom.
Oh, sorry.
And then Senator Pappas.
Thank you, Mr. Chairman. Senator Friends, what is the, there's two provisions I'm told in this bill that were not in 1750. Can you outline exactly what those are?
Thank you, Mr. Chair.
Senator Friends.
Thank you, Mr. Chair. Thank you, Senator. I'll defer to Mr. Carlson on the specifics of the bill, and then, Mr. Chair, hopefully get a couple words in before the committee makes a final decision on the next step for this bill.
Chief Author will have final word. Mr. Carlson.
I'm gonna have Mr. Greenstein answer that question. I know what they are, but I'm gonna have him do it.
Thank you, Mr. Chair. The primary differences between what is in this and what was adopted from our proposal into 1750 is the late fee section. There's a difference in the language regarding late fees. Our proposal actually prohibits charging interest on unpaid assessments, while 1750 caps interest at 8%. Our proposal has a 15% cap of a late fee based on the monthly installment, while 1750 has a $20 or 5% of the total amount owed as a late fee cap. That's a significant difference. There's also a difference in the collection policy language. While they have adopted our concept of the collection policy and some of the notice requirements, that language is slightly different. I believe those are two of the primary differences, although I think there's some grammatical changes and smaller language changes too.
Senator Holmstrom.
Thank you, Chair. Would the author be open to a oral amendment that would change the late fee back to what it was in 1750, which I imagine, off my math off the top of my head, would be lower for the residents?
Mr. Chair.
Senator Frantz.
Thank you, Mr. Chair. Thank you, Senator. I'm open to it, but I have to admit, have not had a chance to talk to other advocates and stakeholders. My intention in bringing the bill forward in its present form unamended is to try to put the non-controversial items together so that if the other bill is not able to be reconciled to the point where it can pass, this will be available as an option to the committee. Long story short, Senator, I'm open to it, but have not had a chance to shop that around, if that's the right term. Thank you, Senator. Thank you, Mr. Chair.
Mr. Carlson or Mr. Greenstein, anything to add on that? Mr. Carlson.
Mr. Chairman and members, I think that's the ongoing conversation that we've been having with everyone. So we're certainly open. If you look at it in legislative terms, they're at 5%. This bill is a maximum cap of 15. Is there a number in between there? Sure, absolutely. But the point is right now, and the reason that this bill is in front of you is because right now there is no limitation on the fee. There is no limitation on charging interest. We have listened to the concerns. We've participated in the task force. We've participated in all of the meetings that have preceded us sitting here today. There are no limitations right now. They've added the disclosure requirements and things that we put in this bill, and I think they should add the bill to Senator Kroon's bill with all of the updates that the real estate section has put in. There's over 300 pages of bills out there dealing with HOA, common interest communities. There's a lot of work to be done here. Are we open to a change on that? Absolutely, Senator.
I won't offer that amendment. I think it's going to be a little bit too much of a lift for our staff at this time, but thank you.
Senator Pappas.
Thank you, Mr. Chairman. Just a question and then a comment. Senator Friends, does Senator Paz and Senator Lucero have a position on this bill? Do they see that as this is the fallback if their work isn't successful?
Senator Frantz.
Thank you, Mr. Chair. Thank you, Senator Pappas.
Senator
That's the
Frantz.
question.
Hold on a second. Senator Kroon,
Sure.
when you have a side conversation, if you could please do it quietly, I'd appreciate it. Thank you. Senator Frantz.
Thank you, Mr. Chair. Thank you, Senator Pappas. That's certainly my hope. And as you can see, members of this committee and Senator Pa, other senators have put in more time on this topic than I have. My hope was that this would be seen by the committee as a bill that would not ruffle any feathers and would be seen as common sense and a possible vehicle to pass something that everyone agrees to. What I'm less sophisticated about is the discussions in the other body and where I don't want to use the word controversial, Senator Pappas, but where the things that haven't been agreed to yet. Some people present them to me as potentially fatal to that bill. I don't know that as well as the members of the other body or Senator Pa. I think my first call when I get off this hearing is going to be to Senator Pott to make sure I understand that a little better, especially if this committee chooses to act favorably on this bill.
Mr. Chairman.
Senator Pappas.
Mr. Chairman, my concerns is that there were dozens, hundreds of meetings with members of HOAs, bringing up all their concerns and all their complaints, and that if we pass a bill that doesn't address all those concerns, then, you know, the world tends to think, oh, we've solved the problem, and then it's a long time before we get back to addressing it again, especially when so much work has gone into it. I think that it's better that we just try to work it out. We still have a couple weeks, try to work it out. Sometimes things can't be a consensus. Sometimes it is going to have to be a majority vote, like the vote on the floor was last year. So again, I want to respect the original authors here and think, again, that we should work through them.
Any further discussion? Senator Limmer.
Thank you, Mr. Chair. Mr. Carlson, could you tell me who the sponsors of this bill is?
Mr. Carlson.
Mr. Chairman and Senator Liver, over the summer, both with my client, other people that are in the HOA board, HOA board members, HOA management companies. We vetted this bill with the MSBA, with legal aid. It took us months to find out, after listening to all the meetings that we also participated in, where there were problems that we felt there could be consensus to add to the conversation. And Senator Pappas, we've been here a long time, and I'm happy having Senator Friends talk with Senator Paugh about this bill before you take a vote on it. We're not trying to do violence to anything. We're trying to see where we can find consensus. There is not, among a broad range of stakeholders, consensus on that other bill. We do want to see something happen. We're not trying to hinder that. We're trying to add things that, as has been discussed, nobody's come in to testify against what's in front of you. We did work to try and get to things that will improve the law for everyone across all kinds of CICs. It's not just a townhome or a condominium. So we're happy to hold this, and I know your agendas are going to be long on the 23rd, 25th, and 27th, because I've already seen the CA's committee notices, but we're happy to have that conversation and hold this bill over to make you more comfortable, because that's not our intent to do damage to any bill that's moving forward. But we do want to see something happen, and some issues are maybe irresolvable, and you do have to have an up or down vote. That is not how CIC bills generally move forward. They generally go forward with consensus, because you're involving, this isn't a tenant situation, you're involving my property rights that I own and I've paid for. So we're happy to take that step and continue to work on this, Senator Latz.
Mr. Chair.
Senator, hold on, Senator Limmer. Senator Frentz, do you concur?
Mr. Chair, thank you. Thank you, members of the Judiciary Committee. I think the best move at this point would be to lay this bill on the table. I think the senators on the committee have raised the right question, which is, what is the path forward for this larger discussion? My intent in bringing Senate File 4035 forward was, as I understood it, these were things everyone agreed to, and I felt there was value in the committee reviewing that and saying, if this is our path, we'll take it. But I think after hearing the questions of the members of the committee, the better path today would be to lay it on the table. And Mr. Chair, as you know, I chair a couple committees myself. I'm very sensitive to your committee's time, and I'm not trying to push work into the future. But for example, would allow me to talk to Senator Pott and others. Maybe there's a way to reach consensus. And I think with that, would ask the chair and members to consider laying this file on the table.
Senator Limmer, before we do that.
Yeah, thank you, Mr. Chair. I would appreciate it, Mr. Carlson, that when you answer a question for me, you don't talk to another senator on the committee. It was quite a lengthy discussion, and I had other questions as well. But if we're considering laying on the table, I'll just stand down on that.
Senate File 4035 is laid over.
Thank you, Mr. Chair. Thank you, members.
Thank you, Senator Friends. Next file is Senate File 4068. This is my bill, so Senator Seeberger will chair.
You got it.
This guy. All right. Senator Latz, welcome to your committee. Tell us about Senate File 4068, please.
Thank you, Senator Seeberger. This is a technical correction and some policy provision changes to the ignition interlock program. I have with me the Peng Zhang from Driver and Vehicle Services who can testify to the specifics.
Welcome to the committee, Mr. Zhang. Please identify yourself and begin your testimony.
Thank you, Madam Chair. Peng Zhang, Director of the Driver and Vehicle Services Division. Thank you for the opportunity to testify on this. Thank you, Senator Latz, for carrying this bill. This bill does a couple of things for the ignition interlock program, and really it's a cleanup from last year's changes. It updates several references to align with the new references or the new current statute. It also makes some clarifications on out-of-state convictions. So there is more clarification on how to administer that, and it aligns the abstinence requirements from 10 to 20 years in alignment with the rest of the changes from last year. In the other part of this bill, it also changes the protection or clarifies the protection around the autism and the mental health indicators, making it clear that it's private data and also providing some federal protections around it, or protections from sharing with federal entities.
Thank you, Mr. Zhang. Are there any questions or comments from members of the committee? Seeing none. Final thoughts, Senator Latz.
I'd appreciate your support.
All right, Senator Latz moves that Senate File 4068 be recommended to pass and be referred to the Committee on Transportation. All those in favor say aye.
Aye.
Any opposed say no. Motion passes and the bill is on its way.
Thank you, members. Senator Westlin, which one would you like to take up first here? 3893 or 3710?
3710.
Senate File 3710 is before the committee. Staff will distribute the packet. While they're doing that, Senator Westlin, to your bill.
Thank you, Mr. Chair. I do have an A9 amendment and this is our second stop, so this is not an author's amendment. The primary thing that the amendment does is on lines 1.3 to 1.10 regards classification of data, definition of street address. The 1.13 to 1.21 has to do with the candidate, the affidavits of candidacy, and we are making some changes, Mr. Chair, and this basically just says that if someone uses an old form for the affidavit of candidacy, that will not be considered deficient. However, for elections then occurring on or after November 4th, an election official would then at that point need to use the correct affidavit of candidacy. So that's what the amendment does.
All right, we're ready to have the amendment handed out by staff, please. Mr. Sigurdson, are you here to answer questions, or did you have something specific to add to Senator Westlin's presentation?
Mr. Chair, just for questions.
All right. Questions. Both testifiers are here for that purpose.
Yeah.
Okay. Let's get the amendment distributed, and then we'll vote on that. Senator Westlin, anything else you'd like us to know about the underlying bill before we take up the amendment?
We can talk about the underlying bill. Basically, Mr. Chair and members, this did pass through, excuse me, through Elections Committee. I believe this also passed out unanimously. Nope, I take that back. It did have bipartisan support, but it was not unanimous. This bill does make updates related to security for election officials. It has a provision to allow for the purchase of security devices. That is located on section, in the original bill, the engrossed version of the bill, lines 4.21. Beginning there talks about security services and items that can be purchased. This also does require that street addresses for individuals be classified as non-public or private data going forward. The bill removes existing requirements related to addresses and privacy on several current reports and forms, so on state and local campaign reports, on which existing requirement that includes the candidate's address. Addresses must still be provided to the Campaign Finance Board, but will be classified as private under this bill. Nominating petitions where there's a requirement that petitions must include the candidate addresses. That has been replaced with a requirement for campaign websites and email addresses if available. There's a section dealing with lobbyist reports. The lobbyist must include the name and address of officials to whom they provided gifts worth more than $5, but just their name, title, and jurisdiction, again, not the address of the elected official. Statements of economic interest that have been updated to allow individuals to have street addresses of real property where they or their spouse live can be classified as private data if the individual certifies reasonable fear for their safety. Candidate street addresses on the economic interest statements are classified as private already. This would be, so under the economic interest statement, that would be additional pieces of property. There's a section on campaign disclaimers. It updates the required disclaimer on campaign materials. And there is a repealer. The repealer repeals existing statute that is unnecessary based on this bill relating to private addresses on statements of economic interest. It also repeals a CFB rule passed in 2025, which has a definition of address that is now codified in the bill. That's a rough run through of the high points of the bill, and of course, happy to answer any questions in detail.
We now have the A9 amendment in front of us. Anything further to share about the A9 amendment before we take a vote on that?
No, Mr. Chair.
Any questions from members of the committee or discussion on the A9 amendment? Not seeing any. Senator Westlin moves adoption of the A9. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Any further discussion from members of the committee or any questions for the testifiers? Not seeing any. Senator Westlin, my notes say this goes to the floor.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. I'm just wondering, does your bill change, I heard you mention disclaimer, I'm trying to find where it is in the bill, but does it change the requirements of the disclaimer on campaign materials?
All right. On page 19, it does. So the required form of the disclaimer, if you look at 19.1 to 19.13, that's the section that deals with the disclaimer. Probably the more important part of this is the address must be the entity's mailing address, an actively monitored email address, or their website if the website includes the entity's mail address or email address.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. So if I'm putting all that together, then you could theoretically put your email address on the disclaimer on your campaign signs, which would be a change from before.
Not on this bill. It's the other bill that says it doesn't, that this applies going after January 1st, so that part is, that language is not here for this. So.
Okay. I'm sorry, Mr.
Senator
Chair.
Westlin.
I'm sorry, Senator Kroon, could you repeat that? So it could be an email address, I think was your question?
Yeah, so like
Senator
let's,
Kroon.
Mr. Chair, sorry, Mr. Chair. Yeah, so my question would be like on a campaign sign, for example, the little disclaimer at the bottom, prepared and paid for, at the name of the committee. Typically, there would be an address. Some people have a street address. Some people use P.O. boxes, which I'm not sure if that complies with current law, but nevertheless, this would allow you to put a website or an email address, and if you put a website, the website would have to have at least an email address, if not a street address. Is that right?
Mr. Chair.
Senator Westlin.
And Senator Kroon, yes, it should be an actively monitored email address, so it shouldn't be some random Yahoo, but something that one is actually checking. And yes, so if you have your website on there, then the website itself has to have the mailing address or the email address, just some way to get to the campaign, and that's the primary purpose is to make sure that people know how to get in touch with the campaign.
Chair.
Senator Kroon.
Thank you, Mr. Chair. Some people might think we're all random yahoos, but
No comment.
Only some of us.
but I think this is a good change because I always wondered with a lot of the things that happened after June. I was like, but yeah, you still are supposed to put an address on your campaign signs, which go out to hundreds of people across the district. And so it sounds like this is a way to address that. So your address doesn't have to be in hundreds of yard signs. So it seems like a good improvement. Thank you.
Any further discussion? Senator Clark.
Thank you, Chair Latz. Senator Westlin, just to be clear on the scope of this, the limiting is just the candidate, or it doesn't fall to treasurer or other folks that may be prominent in a campaign?
Senator Westlin.
Mr. Chair, Senator, as it relates to what?
Senator Clark.
Chair Latz, to making addresses private.
Senator Westlin.
That's why you changed the
So, thank you, Mr. Chair and Senator. So, if you look at line 5.8, it was changed from treasurers to individuals. So it says the board may develop and maintain systems to enable individuals. And so throughout, we're talking about individuals and their addresses.
Senator Clark.
Thank you, Chair. Thank Senator Westlin, and part of it was in regard to Senator Kroon's statement. Perhaps he knows the address on it, but I know there's other campaigns it's treasurers, now it's other individuals on there, so I'm just wanting to make sure that we're mindful that it's not just the individual candidate that might be on there. So thank you for thinking through that.
Any further questions or discussion? Senator Limmer.
Thank you, Mr. Chair. Senator Westlin, could you tell me the context and the definition of the word consanguinity?
Mr. Chair.
On page 4, line 30.
And then spell it without looking at it.
C-O-N-S-A-N-G, U-I-N-I-T-Y, consanguinity. And it means, Senator Limmer, we've had this discussion
I'm listening.
in elections, and not only that, but somebody handed out to you an actual chart of consanguinity, so you should be up to speed on this. It has to do with familial relationships, but you could Google that on that machine you got there.
Any further discussion?
No.
Senator Westlin moves that Senate File 3710 as amended be recommended to pass and be referred to the Senate floor. All those in favor say aye.
Aye.
Opposed? Motion prevails.
And Mr. Chair, I would be happy to get that chart for any person on this committee who'd like to see the consanguinity. Awesome. Okay, Senator.
Senate File 3893, Senator Westlin.
Thank you so much. We will turn to a more serious subject here. So we have seen over the years our election officials in particular and others who have been subjected to intimidation or interference with the voting process. I will note on this bill that this did pass out of our elections committee on a unanimous vote. In 2023, we did pass a law to establish intimidation and interference with voters, election officials, equipment, and so forth. And at that time, we made it punishable by a gross misdemeanor, including costs equal to any damages, as well as a $1,000 civil penalty. This bill actually increases the penalty to a felony. My understanding, Mr. Chair, is that the default felony penalty, because one is not articulated, would be a maximum of 5 years and a maximum fine of $10,000. The current penalties, if you go to Section 211B.075, that is the law that we passed in 2023, and it defines a variety of conduct that we are trying to prevent. It includes intimidation, deceptive practices, interference with registration or voting, and so forth. We continue to have reports, including from the Secretary of State, that election officials and others continue to be and experience significant harassment. I believe that Secretary of State Simon has testified to some specific examples of harassment in recent years that include threatening phone calls. One election official was physically accosted, and I believe in Washington County there was one election judge who shared that some election officials felt that they had to go into hiding due to the level of harassment that they were receiving. We have over 30,000 election workers each year staffing our polling places. These are our neighbors. These are people who volunteer to help facilitate our elections. And so interfering with our election process, intimidating and harassing others, particularly around our free and fair elections, is fairly egregious. And so this bill would seek to increase the penalty to a felony. It does not make changes to the other parts of the law in terms of the definition of intimidation, deceptive practices, and so forth. I'm happy to answer any questions.
Senator Westlin, the bill provides that it become effective the day following enactment and apply to crimes and causes of action accruing after that date. As you know, normally we don't have crimes effective until August 1st. What's your position on that?
Mr. Chair, if the preference, and I understand that, if the preference would be to change it to August 1st, I would be more than happy to accept that as a friendly amendment. Mr. Chair, I guess, if I
Senator
might.
Westlin.
Sorry, Mr. Chair. I guess the only thing, I mean, if that causes enough heartburn for you that you would not vote for the bill, I would be open to changing it. But what I would say
Senator
is.
Westlin, to that point, It is an increase in penalties, but it's already a crime.
Yeah.
So, and given that we're in the middle of an election season or cycle already, I think it makes sense to make it effective as early as we can, because election workers are already active and working.
Right.
So I personally, I think I'm comfortable leaving it as is in the bill.
Thank you. I was going to say, we wanted to certainly make sure it was in place
Any
before
other
the primary.
discussion on Senate File 3893? Senator Holmstrom. And then
Thank you,
Senator
Chair
Limmer.
Letts. Senator Westlin, do we have any information on how often the current law has been charged?
Senator Westlin.
Senator Latz and Senator Holmstrom, I don't know that information.
Senator Holmstrom.
Thank you, Chair Letts. That's something I really like to try to find out, and I guess I could reach out to the BCA myself and see, because I'd like to know how often this is actually a problem that we would increase penalties so severely. But I guess if you don't have it, then you don't have it. Thank you.
Thank you, Mr. Chair and Senator.
Senator Westlin.
Again, I don't have information about who's been charged, but I do have information about the fact that this is sort of an ongoing problem. And when it gets to a point where people feel they have to go into hiding, who are, working as our election judges, I certainly want to make sure that we have a penalty that sort of fits the behavior. But I will see what I can find out for you, and if I do get information about how many people have been charged, I'd be happy to send that on to you.
Sure.
Yeah, of course, there's nothing more fundamental to democracy than elections, so I want to make sure they are free and fair.
Quick.
Senator Holmstrom.
Thank you. Just quick follow-up to that. I guess what I'm trying to get at is I don't know if this is an issue of the penalties aren't high enough to stop somebody, or if it's a failure of prosecutors to actually follow through on the law. That's just what I want to get at here.
Yeah.
Any further discussion on Senate File 3898? Senator Limmer.
Thank you, Mr. Chair. Senator Westlin, I didn't ask you this in Elections Committee, like the previous question.
Yeah, can you spell consanguinity?
Yes. The question I have is, you described this bill focused on intimidation or interference of election officials, but does it focus on intimidation and interference with a voter?
Yes.
Senator Westlin.
Mr. Chair, Senator, and again, I would refer you back to the main part of the bill, 211B.075. The intimidation piece, a person may not directly or indirectly use or threaten force, coercion, violence, restraint, damage, harm, or loss, including loss of employment or economic reprisal against a person, intent to compel them to register or abstain from registering, to vote, etc., or to impede a person's efforts to, with the intent to impede that person's efforts to encourage another to cast a ballot. And then it also, of course, goes to polling places. So it covers everybody. It covers the voter intimidation piece of it, but also covers the election. And so it does specifically also have a section related to interference with registration to voting and so on. So it does go to protecting our voters and making sure that each person has the ability to cast their vote without anyone trying to influence or intimidate them.
Senator Limmer.
I know that, thank you, Mr. Chair. I know that there has been times, stories, not in this state, but where a group of thug-like people will be standing outside of a polling place, sometimes with a gun on their belt or baseball bats in their hands, and they don't say anything, but they give a pretty stern stare to certain people voting. Would that be considered, and would that be provable in a court that that would be intimidation?
Mr. Chair.
Senator Westlin.
Senator Limmer, I would think those things would constitute an attempt to intimidate or interfere. I will say, in our state, we have, you can't, there's a definition of who can be in the polling place. And in that situation, I would think that the election officials might seek assistance from law enforcement. Law enforcement can come to the polling place to, get rid of a disturbance or problems, and they would be able to do that. But I would certainly think that if somebody came into a polling place and they saw those people and felt intimidated by that, I think they would certainly be able to make a police report, and hopefully that would be charged out.
Mr. Chair.
Senator Limmer.
Senator Westlin, I was thinking of a person in close proximity, but they're a certain distance away from the entrance to the building where the polling place is. We can talk about that later,
Yeah.
and I don't know if I know there's a proximity limit to how close you can campaign to a polling place. I was just wondering if there's a proximity standard in existing law, but we can discuss that
Yeah.
another time.
Mr. Chair and just Senator,
Senator
there
Westlin.
is a specific definition of who can be at the polling place, and if you are not one of those people, you are not allowed to be at the polling place. So I think that would cover that situation, but yeah, we should talk about that.
Further discussion on Senate File 3893. Not seeing any. Senator Westlin moves that Senate File 3893 be recommended to pass and be sent and be re-referred to the Senate Committee on Finance per fiscal staff. Mr. Turner?
Yes, Mr. Chairman, the bill creates an unranked felony. I don't expect it to come back costing state beds, but it needs to be run through the fiscal process nevertheless. And if it comes back with no cost, you can pull it out of finance and send it to the floor.
All right. Senate File 3893, recommended to pass and re-refer to the Senate Committee on Finance. All those in favor say aye.
Aye.
Opposed? Motion prevails. Thank you, Senator Westlin. I have another bill from Senator Westlin just being handed to me, Senate File 3607, Minnesota Human Rights. If you have any testifiers, they can come forward right now.
Thank you, Mr. Chair. And we do have a testifier who can come forward.
I think I saw the commissioner arrive earlier. When you're ready, Senator Westlin, go ahead and describe the bill.
Thank you, Mr. Chair. This is 3607, and as committee members may remember, we had this conversation about notices originally it was employment, places of employment, and also educational institutions. And as promised, Mr. Chair, I said I would come back with this bill, and I have in fact come back with this bill to this committee. So this bill has undergone some changes in the Labor Committee, and change number 1 would be lines 1.17 to 1.19. Again, as promised, there's language that says the commissioner shall consult with the Commissioner of Labor and Industry to create and distribute an educational poster providing notice of employee rights provided under this chapter. Members may remember, and Senator Latz, I think you missed that entire conversation, but there was concern about the fact that that language was not in the bill when it came before this committee. So it will be up to the commissioner to prepare these posters in conjunction and consultation with the Commissioner of Labor and Industry, and those will be provided to any entity. We did take out the section that dealt with educational institutions, so this is a much smaller bill, and we are now only focusing on workplaces. I do want to reiterate that the point of this bill really is to ensure that we are providing notification and notice in workplaces regarding individuals' rights under the Human Rights Act. It is a poster with notice, not unlike other employment notices that one would find in places of business.
Any discussion, or do we want to have testimony from Commissioner Lucero? Just available to answer questions?
Yes, sir.
Any questions or discussion from members of the committee? Senator Holmstrom.
Thank you, Chair. Senator Westlin, is there any other requirement to post rights that do not specifically relate to employment at places of employment?
Mr.
Senator
Chair
Westlin.
and Senator Holmstrom, I believe these do relate to employment.
Senator Holmstrom.
So all of the Human Rights Act all of our Human Rights Act is directly related to employment.
Senator Westrom.
I don't understand the question.
I think Ms. Primo can clarify.
I guess I
Overheard
just,
her, Ms. Primo.
I'm not tracking, sorry.
Mr. Chair and members, the way I read it, on line 1.8 to 1.9, it says notice of employee rights that are provided under this chapter. So I'm guessing it would have to be confined to whatever is applicable to the employment.
Senator Holmstrom.
Thank you. I missed that on the read of the new language. I appreciate it.
Any further discussion or questions? Not seeing any. Senator Westlin moves that Senate File 3607 be recommended to pass and be referred to the Senate floor.
Yes.
All those in favor say aye.
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 Opposed? Motion prevails. Thank you, Mr. Bauer, Commissioner Lucero, for being here to answer questions.
Only 6 more of my bills to go, so stay tuned.
All right. I heard we are in the presence of Senator Dibble. Is that correct? I don't see him.
Following that brief intermission. Consanguinity. It's a great word. Oh.
Senate File 1943, Senator Dibble. We're going to distribute the packet to members. You can go ahead and describe your bill while we're doing that, please.
Thank you, Mr. Chair. And when the time is right, there is an small A4 amendment. Which I'll describe as things start coming around.
Yeah, just give us a brief description of the whole bill and then focus on the provisions before this committee, please.
Great, thank you. So, Mr. Chair, members, at its core, Senate File 1943 is a consumer protection and transparency bill to address a specific retail practice, which is the third-party sale of dogs and cats through pet shops. It seeks to accomplish 3 things: prohibit prospectively, so in the future, new pet shops from selling dogs and cats, while those existing stores are grandfathered to allow them to continue to operate and even sell their store and continue on in that manner if they see fit to do so. It strengthens disclosure requirements so consumers know the origin and history of the animals they purchase. As I mentioned, existing stores may continue to operate if they source from licensed breeders and comply with those disclosure requirements. And consumers must receive breeder information, health disclosures, inspection reports. Local governments do retain the authority to enact stricter ordinances. What brings the bill here is in Section 5, the civil penalties establishes that violations of disclosure requirements and violation of the prohibition on unlawful pet shop sales are subject to a civil fine of $1,000 per violation with each unlawful sale constituting a separate violation. Again, it's civil, not criminal, consistent with existing enforcement structures under Chapter 325F. The bill, Mr. Chair, as you recall, garnered some conversation and debate. I think it was represented at the last stop that there had been a number of compromises that had been achieved, and more to come. So Amendment A4 is fulfilling that direction from the prior committee that would limit or eliminate the disclosure of breeders and license numbers and the like in advertising, and limit that only to on-premise, on the cage of the animal in question. So rather than after the point of sale, if a customer wanted to know who a breeder was in the store, they could take a look at that. But it excludes those kinds of disclosure from advertising online or otherwise, which was a concern of the proprietor. And I believe if the A4 is adopted, we would have the proverbial peace in the valley.
Section 5 and Section 6 involving severability are both specific focus of this committee, but the author has asked us to consider the A4 amendment as well, which is a little broader than our jurisdiction, but this came to us from Commerce. A number of us already heard the bill in Commerce. So let's go ahead and consider that. Any questions on the A4? Senator Kroon.
I'll move the A4.
Senator Kroon moves adoption of the A4 amendment. Any discussion? Senator Limmer.
Mr. Chair, I thought that severability clause was already assumed in Minnesota statute.
Senator Limmer, I'm sorry to interrupt you. On the A4 amendment, please. And
Oh,
we'll come
I'm
back to
sorry.
that.
I'm sorry, I'll back up.
Okay. Any discussion on the A4? All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Senator Limmer.
Yes, going to page 5 of the bill, there's a reference, section 6, severability. I thought that there was already a severability assumption in existing statute. Is that correct? Perhaps council can answer.
Ms. Primo.
Mr. Chair and members, yes, under Chapter 645, there is a presumption of severability.
So the question
Senator Limmer.
remains, do we need that in the bill?
Ms. Primo, any thoughts on that provision? Or that question?
Mr. Chair and members, because of the presumption under Chapter 645, you don't need it. Sometimes various advocates may just want it in there anyway. That happens sometimes. So it's a decision for the author and the committee to make.
Ms. Primo, does it have any negative effect on the bill or on Chapter 645 if we do it this way in the bill as well? Any reason not to do it this way?
Mr. Chair and members, I'd have to compare the specific language here with what's in 645 to determine if there is, is there any conflict? Does this miss what's included in our presumption in 645? So that would be the one negative to including it.
Senator Dibble, thoughts?
Mr. Chair, I have, I throw myself at the mercy of the Judiciary Committee.
Uh-oh. Don't ever say that.
The wisdom of my dear friend, who I will miss next year, Senator Limmer.
Mr. Chair.
Senator Kroon.
Could always replace it with a non-revival clause.
I did not hear a motion. Senator Dibble, advice of counsel is that the presumption and statute's been on the books for decades, and there's probably case law relating to it. Maybe better not to add any potential confusing language to a specific statute and set the precedent for doing that as well. So are you okay with removing it, Senator Dibble?
Only if Senator Limmer makes the motion.
Senator Limmer moves to strike Section 6 from the bill. All those in favor say aye. Opposed? Motion prevails. The amendment is adopted. Any further discussion? If we can focus on Section 5, if there's anything. Senator Kroon.
Thank you, Mr. Chair. I'd just like to thank the author for his persistence in reaching peace in the valley. This has been an ongoing issue for a long time in my district, and I appreciate your work to bring the parties, at least to not oppose the bill. I think that's it's a good result, and I appreciate your efforts.
Thank you.
Seeing no further discussion, Senator Kroon moves that Senate File 1943 as amended be recommended to pass and be sent to the Senate floor.
All right.
All those in favor say aye. Opposed? Motion prevails.
Thank you, Mr. Chair and members.
Senator Dibble, we got another bill for you here, Senate File 2972. This relates to nursing homes. Senator, when you're ready, go ahead and let us know briefly what the bill involves, and then I'll turn members' attention to sections 10 and 12 for our committee's consideration.
Thank you, Mr. Chair. And then when the time is right, we do have another A4 amendment that would delete and replace Section 12. So very quickly, what this underlying bill seeks to do is to address problems that have cropped up with the rapid shift in ownership and control of long-term care facilities by for-profit entities, including private equity-backed firms. These transactions often involve complex ownership structures, related party contracts, real estate arrangements, and they result in staffing reductions, asset stripping, rising costs for residents, declines in quality of care. There's a lot of investment. It's considered a growth market. However, these are the homes of our parents, our spouses, and loved ones. And so it's an attempt to create some guardrails from those who would seek to profit and then in so doing decrease the care for medically fragile elders. It has two major components. The first is it strengthens staffing standards, establishes clear enforceable staffing requirements, on-site coverage, minimum levels, competency standards. There's a waiver process within the staffing standards, and that provides for transparency but provides for flexibility. And then it also seeks to regulate the ownership, transfer, and corporate practices of these for-profit entities with advance notice and disclosure of ownership structure, financial condition, regulated party business arrangements, disclosure of regulation and litigation history, demonstration of fitness to operate financially, and make sure that their compliance records are clean. There's a commitment to reinvestment and quality of care, and a track record on Center for Medicaid and Medicare services ratings and facility performance. It specifically also prohibits practices that we know harm residents, including interference with clinical judgment, self-dealing and asset stripping, unequal treatment of residents, failure to reinvest in care and infrastructure, excessive cost increases beyond the consumer price index without justification, and allowing quality ratings to decline. It has some enforcement mechanisms that brings us here, asking the Attorney General under Minnesota Statutes 8.31 to enforce. And then Section 12, Mr. Chair, would be replaced, as I mentioned, by the A4 if the committee sees fit to adopt the A4 amendment. And I can describe the A4 if you like.
Yes, Senator Dibble, go ahead.
So it would establish, it would replace a fairly small enforcement section with stronger, more effective framework to empower the Attorney General to seek injunctions or unwind transactions that violate the law. Does not require the Attorney General to achieve a threshold of proving irreparable harm, only that a violation has occurred. This is important so that cases can move quickly, because delay can mean irreversible harm to residents. It enforces the transparency requirements in the bill. Failure to provide required information is itself grounds to block or unwind a transaction. This is important so that entities cannot delay, obscure, or evade scrutiny. It makes use of existing consumer protection authority. The Attorney General may enforce violations under Minnesota statutes, like I said, 8.31. This aligns these cases with well-established enforcement tools already used in other sectors. It establishes meaningful penalties, which you can see, up to $50,000 violation for individuals, $500 for entities, attorneys' fees and costs. Mr. Chair, it's an attempt to calibrate appropriately to ensure that there is deterrence, there is accountability, and that this measure remain proportionate relative to other healthcare transaction laws.
Any discussion or questions from members of the committee regarding the proposed A4 amendment to replace Section 12 in the bill itself? Senator Limmer.
Mr. Chair, could we have counsel tell us what our jurisdiction is on this bill?
Sections 10 and 12, Senator Limmer.
Thank you.
Any further discussion on the A4 amendment to replace Section 12 in the bill with the language in the amendment? Not seeing any discussion, Senator. We need to amend the effective date on the A4 amendment to 2026 as well. Council advises, so Senator Westlin moves the adoption of the A4 amendment with the amended language on line 1.29, changing 2025 to 2026. Any further discussion? All in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. The amended bill, sections 10 and the new section 12. Discussion. Senator Cruin.
Thank you, Mr. Chair. And I'm about to cite from section 11, but bear with me. I think you'll find it's relevant to our jurisdiction. It's a question regarding the rent control provision, line 9.14 to 9.17 of the underlying bill, and specifically the last part of it in 9.16 to 9.17. It provides for an exception if the for-profit entity can demonstrate that the increase was justified by legitimate business expenses. Who is that justified to? How does that work?
Senator Dibble.
Thank you, Mr. Chair. I have my phone a friend here, Mr. Burke, who can help, but I'll take the first stab. I believe it's the Department of Health who would.
Mr. Burke, if you give us your full name and your affiliation, then go ahead.
Chair Latz, my name is Sean Burke. I am with O'Connell Consulting. We represent the Minnesota Elder Justice Center, who's among a coalition of advocacy groups bringing this bill. It would be both the Department of Health, but also then the AG enforcing this section, who would be scrutinizing the legitimate business expense.
Chair.
Senator Cruin.
Thank you, Mr. Chair. So I understand if it's the AG, that's an enforcement action after the fact, but the Department of Health, is that, would that be available as a mechanism for pre-approval for that increase?
Mr. Burke.
Chair Latz, Senator Kroon, under the current language, there is not a pre-approval process that MDH would be looking at, no.
Senator Kroon.
Thank you, Mr. Chair. Then what is the Department of Health's role in making that determination whether the increase was justified by legitimate business expenses?
Mr. Burke.
Senator Chair Latz, Senator Kroon, Under the process of enforcement from the AG has, in conversations with the Attorney General, they have talked about the need to consult with the health department. And so under the bill, there's not like a formal process that you may be referring to, but it would be in consultation between the AG and the agency, similar to what the AG currently does with their Medicaid fraud assistance unit, the MUFUKU, which doesn't have, those statutes don't have like direct processes by which the agency is like pre-approving something, but the AG is working in concert with the agency.
Chair?
Senator Kroon.
Thank you, Mr. Chair. So if I'm understanding your response, let me know if I got it right. If the for-profit entity feels like they need to increase the rent beyond what's allowed here, they would consult with the Department of Health and get essentially an advisory opinion. And if the Department of Health said, yes, that makes sense, and then the AG were later to start an enforcement action, then the for-profit entity could say, but I consulted with the Department of Health, and that would kind of be a defense. Is that kind of how you see that? Or maybe the AG wouldn't bring the action at all if the Department of Health had said, yes, this is justified.
Mr. Burke.
Chair Latz, Senator Kroon, yeah, I think that's a great example and a concept, a way the process could work, that pre-approval, as you described it, isn't in the statute, so a provider might not know how to do that, but would definitely be, the way you described it is what would be envisioned right now.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. And we had a similar discussion, previous bill hours ago, that I'm sure you weren't here on, but I always think that if there's a formal pre-approval process, whenever you're talking kind of like a rent control kind of thing that has some exceptions, to me it makes sense to have a pre-approval mechanism for the legitimate business expenses as provided in the statute, because otherwise you're kind of hoping, you don't want to have to deal with that in an enforcement action by the Attorney General. It'd be nice if you're a legitimate provider and you want to do this the right way, you got some expenses that are out of the ordinary or whatever, and you need to go above that amount, I'd like to see a formal mechanism for them to say, hey, here's the deal, here's what we're proposing, what do you think about this? Get some sort of approval, and then not have to worry about Attorney General enforcement after the fact. I don't know if that's something that you all considered.
Mr. Burke.
Chair Latz and Senator Kroon, I don't think that's a bad idea at all. In fact, there's a different bill that we've been working on specifically in the assisted living space, trying to make sure that price increases are more transparent and starting to give the Department of Health some more authority around the price increase concept, which to this point, they're an agency that hasn't been given a lot of authority in terms of like that level of business scrutiny. And I can see the concept that you're describing being wrapped up in that regulation. And so it's not just a creative, I think it's a good and practical idea.
Senator Kroon, any follow-up or no?
Thank you, Mr. Chair. Now I'm starting to wander into health areas that I'm not an expert on. So I'm a little reluctant to propose an amendment on the fly, but it sounds like that you said there's another bill out there that this concept could be rolled into?
Mr. Burke.
Yeah,
Senator
Senator Latz, yeah, Senator Mann is pursuing a similar bill. And Mr. Chair, this bill is either going on to finance or back to human services, whatever the pleasure of the committee is. So we can delve into.
It's up to you. We don't have any guidance one way or the other on that one.
Right.
Mr. Chair.
All right, Senator Kroon.
Thank you, Mr. Chair. Well, since Section 11 isn't technically in our jurisdiction, and thank you for the indulgence for letting me do this on Section 11, maybe I could just follow up with you all and see if there's an opportunity to incorporate this, and if it works, it works. If it doesn't, it doesn't.
Mr. Chair.
Senator Cronin, it'll come out of your time somewhere else in the agenda. Senator Dibble.
I do know that it is the intention of the Chair of Human Services to incorporate either all or part of this language in his larger bill that he's compiling. So there'll be opportunity to do that.
Any further discussion of sections 10 or 12? Senator Clark.
Thank you, Chair Latz. Thank you, Senator Dibble, for this bill. A quick story, and thank you on adding the transparency pieces here. In my neighborhood, there is a longtime beloved nursing home, Bethany, that was up and running wonderfully for years, and then started going down this private equity firm piece, and then they eventually had to shut down. And the problem was not that it was acquired by who it was acquired by, it was the fact that we could not figure out what the contact address was. And so it shut down, became an abandoned building next to an elementary school that just slowly began to deteriorate. And because it was passed from entity to entity to entity, the city was not able to contact or connect with anyone. And it fell into disrepair. And this helps solve that small piece to ensure that we can hold bad actors accountable by putting more transparency in. So thank you for this addition.
Thank you, Mr. Chair.
Anything further? Senator Dibble.
I'll just say, yeah, this is a distinct problem that has been identified on numerous occasions by the Ombudsman for long-term care, where the entity, if there's a citation and a remedy that needs to be effectuated, it's a P.O. box in New Jersey. It's very frustrating.
Any further discussion? Not hearing anything. Senator Dibble, where would you like this to go from here?
Let's just send it back to
Health and Human Services?
Just
Human Services?
Human Services.
It's always confused me there. Senator Clark moves that Senate File 2972 as amended be recommended to pass and be re-referred to the Senate Committee on Human Services. All those in favor say aye. Aye. Opposed? Motion prevails.
Thank you, Mr. Chair and members.
Thank you, Senator Dibble. Next stop is Senate File 3959. Senator Seeberger, could you take the gavel?
I apparently deleted it.
Okay.
So
Okay.
So
Hold on. Nicole can give the line-by-line walkthrough too.
Senator Clark, welcome to the Judiciary Committee. Can you tell us about your bill, please? We are on Senate File 3959.
thank you, Chair. Let me restart. Thank you, Chair. Senate File 3959 is our stay-at-home bill. This bill makes targeted practical updates to strengthen Minnesota's address confidentiality program, Safe at Home, and protect participants who rely on the services for their safety. I think we're all probably fairly familiar with Safe at Home, but for those who are not, Safe at Home helps people who fear for their safety, often survivors of domestic violence, sexual assault, or stalking, but also those with professional safety concerns, keep their real addresses confidential. Participants are given a P.O. box to use as their legal address, which must be accepted by public and private entities so they don't have to disclose where they live. The program forwards participants first-class mail and accepts service of process on their behalf while securely protecting their actual addresses. This bill starts by clarifying gaps in current law, defining who may act as a guardian when enrolling a minor, and ensuring emancipated minors can apply independently. It also codifies the existing staff practice of requiring documentation of guardianship to promote consistency and accountability. The bill strengthens protections around disclosure of a participant's physical address by requiring written judicial findings, notifying the Office of the Secretary of State when such findings are made, and allowing time for review or intervention before the disclosure takes effect. It also enhances penalties for harmful disclosures, adds discrimination protections for participants, and improves state agency coordination by requiring agencies to designate a safe-at-home point of contact. It reduces barriers for participants by allowing safe-at-home cards to be used as proof of residency for driver's license and real IDs, and it requires judicial training to reinforce the seriousness of these protections. In the other body, it's carried by Representative Nash, who in part is carrying this due to a story from a constituent of his and the real effects and harms that a gap has created for that person. These are straightforward updates that ensure the program remains consistent, clear, and effective for those who depend on it. And I have staff from Secretary of State's office with me to review sections of the bill and to answer questions. Ms. Freeman may be available to go, as well as Ms. Strother.
Ms. Freeman, please identify yourself and begin your testimony.
Thank you, Madam Chair. My name is Nicole Freeman with the Office of the Secretary of State. I'll do just a very brief run through of each section, and then both Ms. Strother and I are happy to answer any questions you have. So Section 1 clarifies who would qualify as a guardian when enrolling an eligible minor. It also adds emancipated minors to the definition of an applicant, as the senator just said, so that they can apply on their own. I will note we do have an author's amendment. That author's amendment removes proposed changes that are in the underlying bill that relate to addresses about participants' businesses. Section 2 requires guardians applying on behalf of an eligible minor to submit court orders showing the custody agreement. This formalizes current practice and is to ensure that our staff know who is responsible for those minor children. Section 3 would be removed by the author's amendment when that hopefully is adopted. That section proposed clarifications about banks accepting safe-at-home addresses for business accounts. This section, along with the provision in subdivision, or in Section 1, are provisions that we actually found through working with partners that we can address in other ways, and so we're pulling those out of the bill. Section 4 requires judges to document decisions when ordering participants to disclose their physical address. It requires them to notify the Secretary of State when the disclosure is ordered, and also allows for time for review or intervention before that disclosure takes effect for the participant. Section 5 increases the penalty for harmful disclosures of safe-at-home data to a gross misdemeanor. Again, in the underlying bill, it is a felony. In the amendment, we're seeking to just bump it up to a gross misdemeanor. And the penalty for disclosure of the safe-at-home data, the increased penalty comes into play when bodily harm occurs. Section 6 prohibits discrimination against program participants, and in the author's amendment, we intend to add a reasonable person defense there. Section 7 requires state government offices to designate a safe-at-home contact person to improve response times for our participant. Not looking to add any new work, but just streamline how that contact with state agencies and state offices is done. Sections 8 and 9 allow safe-at-home cards to serve as proof of residence for driver's license, Minnesota IDs, and real IDs. The author's amendment makes a slight change there to exclude temporary cards. Section 10 requires judges to receive training on the Safe-at-Home program, and sections 11 and 12 will be removed in the author's amendment. Thank you, Madam Chair.
Thank you. Our next testifier is Julie Strother. Could you please, oh, you're not testifying?
I'm here just to answer questions, Madam Chair. Thank you.
Understood. Thank you very much. Senator Clark, did you want to move your author's amendment?
Yes, Chair, I move the A1.
Senator Clark moves the A1 as an author's amendment. All those in favor say aye. Aye. Any opposed say no. The amendment is adopted. All right, any questions or comments from members of the committee? Senator Holmstrom.
Thank you, Madam Chair. Senator Clark, on page 2, line 10, it states guardian acting on behalf of an eligible minor means an adult who has legal custody of a child pursuant to, either way. My question is, if a parent has split custody, can they use this language to enroll their child, therefore hiding the location or, any data from the other parent?
Senator, Ms. Strother.
Madam Chair, Senator, they would have to have full legal custody of the child to make that. And that's why we're requiring a court order, so we can assess what authority that parent has to enroll a child.
Senator Holmstrom.
Okay, and I guess my clarifying question is, should it say full legal custody, or is it just saying legal custody is that enough of an implication? Maybe that's a question for council.
Chair, that's on 2.10.
Senator Clark, yeah. Who wants to take that one?
I'm hoping Ms. Primo, Chair, I'm hoping Ms. Primo.
Ms.
has
Primo?
a comment on that.
Mr. Chair and members, I'm just looking at those two sections that are cited are not related to parental custody. Those are, it looks like, when there is no parent and a guardian some other individual is court ordered and placed, or another custody arrangement that is approved by the court. It would depend on what that court order says and the authority that the court order gives to the guardian, or if this does cover parental arrangements, the parent. So I think it would be a case-by-case determination of what the court order states. Is it legal custody, or something short of that? And I think the Secretary of State's office would have to read that order and make that determination.
Senator Holmstrom.
Thank you. So I want to clarify. So your recommendation is to not add anything to that language. It's clear enough.
Ms. Primo.
Mr. Chair and members, it seems clear to me, but I think it may be, if the committee is concerned with some specific thing I'm not thinking of, I'm happy to try to address that. But for purposes of the bill, it seems to be written clearly.
Senator Holmstrom.
That's good enough for me. Thank you.
Senator Westlin.
I was just going to say that this particular, so it's referring to 260C.325, which actually deals with where there's been a termination of parental rights. And so this is a person who has been designated by the court as the guardian. I don't know if that helps or not, but anyway, my 2 cents.
Any other questions or comments from members of the committee? Senator Holmstrom.
Sorry, maybe this is a question for Senator Westlin. I'm not sure. Yeah. Is there such a thing as joint legal guardianship in these situations?
Senator Westlin. So I don't know about, so I suppose that the court could, a married couple has guardianship of a child, they could have that. But joint legal custody is a term, single legal or sole legal custody is a different term. And I think this is dealing with a situation where somebody has a specific court order that clearly designates that they are the person that has the legal authority. So all these terms get a little mixed up with each other. But this would be a situation where this person has a court order that's appointed them specifically, and that there's been a termination of parental rights under that particular statutory reference.
Senator Holmstrom, good?
That's all. Thank you.
All right. Any other questions or comments from members of the committee? All right. Any other amendments? Nothing. All right. Closing comments, Senator Clark.
Thank you, Chair. This makes good improvements on an already good program that we can continue to ensure that folks are safe at home. And Chair, I believe the next step for this is on to transportation. And state and local wants it too. You want state and local?
All right, Senator Clark moves that the Senate File 3959 be recommended to pass as amended and be referred to the Committee on State and Local Government. Is that your motion, Senator Clark?
Let us,
All right, stand by.
okay. Chair, I believe that transportation is scheduled before state and local government.
Understood. Senator Clark withdraws his prior motion and makes the motion that Senate File 3959 as amended be recommended to pass and referred to the Committee on Transportation.
Yes, I do. I make the motion.
All right. All those in favor say aye.
Aye.
Any opposed say no. The motion prevails and it is on its way to transpo.
Thank you.
Senator Kunish, you're up. Our next bill is Senate File 3625. I believe staff is disseminating that to the members. Senator Kunish, welcome to the Judiciary Committee. While the bill is being passed out, tell us about Senate File 3625.
Well, the full bill here is actually the PELSB bill, the Professional Educator Licensing and Standards Board, but it's really only Section 4 that pertains to this this committee, and so I'd like to invite the Director Bailey to share the information and explain what it is that you need to hear.
Fantastic. Dr. Bailey, please introduce yourself and begin your testimony.
Thank you, Chair, members of the committee. My name is Dr. Elena Bailey, and I am the Executive Director of PELSB, the Professional Educator Licensing and Standards Board. As Senator Kunish mentioned, this is largely an operational bill, but I believe Section 4 is before this committee today, and that addresses a data sharing agreement that we're looking to enter in with the Board of School Administrators, otherwise known as BOSA. So we currently have an existing data agreement with the Minnesota Department of Education and are looking for a parallel agreement with BOSA. PELSB as an agency is responsible for collecting all of the school employment and assignment data across the state of Minnesota. And so the Department of Education and the Board of School Administrators often need that data to perform their jurisdictional duties. Right now, we're unable to share data with BOSA until it becomes finalized in public. This would allow us to share data before it's public between agencies for the purposes of addressing complaints and ethics investigations and verifying teaching or administrator experience in order to issue licenses in a faster manner.
Thank you, Dr. Bailey. And I believe for members of the committee, we are focusing on Section 5, which contains the language we are going to be discussing.
Yep, I apologize.
No problem. We're good. All right. There's no other testifiers? Okay. Any questions or comments from members of the committee? Senator Limmer.
Thank you, Madam Chair. Senator Kunish, could you tell me, maybe I missed it, what kind of information is being transferred?
Thank you, Mr.
Senator Kunish.
Thank you, Senator Limmer and Chair. And I'm going to let Director Bailey respond to that.
Dr. Bailey.
Chair, Senator Limber, great question. So this would be data on teaching or administrator assignments. So employment data of where they're working, what assignment they're working in, that the Board of School Administrators needs to verify. For example, to issue certain licenses, you need to be in a position for X number of years. We have that data for about 6 months before it's public, so they would like to be able to access that so they can issue those licenses. The other data is when there are complaints from parents, for example, about teachers working in assignments where they're not appropriately licensed and they need to look into whether an administrator is carrying out their ethical duty, they need to be able to get the information on what was reported to us for those teaching assignments, but we can't share it until it's public, so that delays those investigations.
Senator Limmer.
Senator Kunish, could you tell me, is there, this data, does it have a specific data classification at this time?
Senator Kunish.
Thank you. Again, just so that we're really clear and I don't give you the wrong answer, I'd like Executive Director Bailey to respond to that.
Dr. Bailey.
Chair, members, great question. So it becomes public data, but while we're processing it, it's not public data.
Senator Limmer.
And Madam Chair, and perhaps I should direct the question to the testifier. At the current time, it's private, and as it's transferred to another entity, do we have assurance that that data privacy standard follows that data wherever it may go?
Dr. Bailey.
Chair, members, great question. So yes, because we already have those practices in place for sharing that same data with the Department of Education, so we continue those practices.
And Madam Chair,
Senator Limmer.
does this data ever leave the state of Minnesota?
Dr. Bailey.
Chair, members, not until it's public. So once it's public data, it's available on our website and our dashboards, usually in aggregate form or if there's data requests, but not until it's public.
Okay.
Senator
Madam Chair,
Limmer.
the reason I ask that, and I ask that often, is that whenever, and it cautions us, because whenever we send data outside of the state of Minnesota, despite our classification of private data, we cannot enforce our standard once the data leaves our state. So we have to be cautious about that. But thank you for answering. Appreciate it.
Any other questions or comments from members of the committee? Senator Kroon.
Thank you, Madam Chair. So the data classification is found in what was sub E, which is now going to be sub F. And you're just adding another sharing agreement to the statute, but the data classification stays the same. Is that right?
Dr. Bailey or Senator Kunish?
From what, yes, that's what I understand.
Senator Kroon? Good to go. Any other comments or questions? All right, closing thoughts. Senator Kunish.
Just that I appreciate these really good questions and would appreciate your support in moving 3625 along.
All righty, so Senator Clark moves that Senate File 3625 be recommended to pass and be referred to the Committee on Education Finance. All those in favor say aye. Aye. Any opposed say no. Motion prevails and the bill is on its way. Thank you, Senator Kunish. Our next bill will be Senate File 3548. And while staff is distributing those materials, Senator Westlin, can you tell us about the bill?
Thank you, Madam Chair, and thank you, members. This is a bill that would require athletic coaches and assistant coaches to be trained in CPR and the use of AEDs. As you know, I've had bills in the past regarding schools establishing cardiac emergency response plans. The one thing that we have discovered is that some of our athletic coaches and assistant coaches may be trained in CPR, but not all of them are. We heard many stories in the Education Finance Committee about young people in particular who are having these cardiac events and how critical it is to have someone trained and able to intervene quickly. There are many resources that are without cost for our coaches and assistant coaches to be trained. What we do know is that when there is immediate intervention within the first couple of minutes, the chance of survival goes up multiple times, and I know our chair paramedic would probably be able to speak to this as well. We did hear some very heart-wrenching stories. One mother who was at, I believe it was a softball game, and her daughter just sort of fell backwards after stealing third base, I believe. And initially, folks thought she was having a stroke or a seizure of some sort. Her mom happened to be an RN, and her mom came and assessed the situation and immediately began CPR. The coach also testified at this hearing, and he was in tears because he had not been trained in CPR and felt so terribly and felt so helpless to be standing by and watching mom literally save her daughter's life. This is something that should be fairly easy, and it just seems that when we're having kids participating in athletics, that it makes sense for their coaches and assistant coaches to be trained. The reason why this bill is in front of Judiciary is on lines 1.15 to 1.18, and this does create, in essence, a Good Samaritan provision. So if an individual who's described in this section performs CPR or uses an AED in the course of their employment as an athletic coach, they are not liable in a civil action for damages except for gross negligence or willful or wanton misconduct. So we are trying to make sure that we are not creating liability for folks who are trained then in CPR and the usage of AEDs. And so that provision, I believe, is the one that brings us to Judiciary today.
All right, thank you, Senator Westlin. Any questions or comments from members of the committee? Senator Kroon.
Thank you, Madam Chair, and I'm assuming this is not the first liability exemption that we have in our statute books, and I'm assuming the gross negligence or willful or wanton misconduct was borrowed from another place in statute. Is that a fair assumption?
Senator Westlin.
Madam Chair, Senator, I assume so, but I guess I don't know the answer to that question, and I don't know if council can answer that question, but I don't know the answer to that, Senator.
Ms. Primo, do you have any insight?
Madam Chair and members, yes. The specific exception for gross negligence, willful wanton misconduct is pretty typical. I'm just searching through Minnesota statutes, and that does appear a few times. The idea is that you don't want someone to be liable. Usually the goal is for negligence, but preserving the ability to be liable for something more than negligence. That tends to be common.
Senator Kroon.
Thank you, Madam Chair. Thank you, Council. The only reason I ask is because it gives comfort to know that this language is used in other places, because courts engage in statutory interpretation, and we should be careful to not insert new clauses and things that will cause courts to have to reinvent the wheel. So if this is already in our statute books and other places, then I think it's good.
Thank you.
Any other questions or comments from members of the committee? I have a question. Who on the committee knows how to do CPR? Oh, see? Senator Westlin.
So, Madam Chair,
Senator Westlin.
I was signed up to take CPR and AED, and I had a conflict because of this legislature, so I will be signing up for CPR and AED training.
I hope you do. I hope everyone does. All right. Ed policy?
Yep, we're going to send it back to policy.
Senator Westlin, I assume you will move that the Senate File 3548 be recommended to pass and referred to the Committee on Education Policy. Is that your motion?
Yes, ma'am.
Motion. On Senator Westlin's motion, all those in favor say aye.
Aye.
Any opposed, say no. The motion prevails and the bill is on its way. Thank you, Senator Westlin. Don't move.
Madam Chair, I actually think you could do that training for members of this legislature.
While I certainly have the knowledge and know-how, I am not certified as a CPR instructor. But thank you for that. All right, moving on to 49, Senate File 4292. Senator Westlin, to your bill.
Thank you, Madam Chair. And thank you to Superintendent Evans, who has had the pleasure of sitting through hours of judiciary today. Thank you, Madam Chair, and thank you, members. Senate File 4292 is a BCA policy bill that's designed to address some of the gaps in Minnesota law. regarding law enforcement's ability to prevent child sexual abuse and the exploitation of children. This bill clarifies the jurisdiction for CSAM, or child sexual abuse material, prosecutions to prevent delays, so there's some venue provisions there. It clarifies when law enforcement are executing a search warrant in a CSAM investigation, they have the authority to conduct an on-scene preview of digital media they find, similar to being able to open a locked file cabinet. So it's a quick review just to see whether or not there is material located on the digital device. And then finally, this bill contains several provisions that are designed to address the proliferation of childlike sex dolls in Minnesota. It would make it a crime to possess a childlike sex doll, requires sex offender registration for that offense, and makes it illegal to create or disseminate these dolls in Minnesota. It also creates an affirmative defense to crime victims of trafficking. Reports related to child sexual abuse material have continued to increase, and this bill provides important tools to help address this serious issue. And then I would kick it over to Superintendent Evans to share some additional information on this topic.
Superintendent Evans, welcome to the committee.
Thank you, Madam Chair, members of the committee. For the record, my name is Drew Evans. I'm the superintendent of the Minnesota Bureau of Criminal Apprehension. I think Senator Westlin did an excellent job of giving an overview of the provisions of this bill. Just a little bit of insight as to some of the reasons that we're bringing it in front of you today. The first one, as was outlined for venue provisions, what this does is provide clarification for the charging venue when we identify somebody that is in possession or distribution of child sexual abuse material. The Bureau of Criminal Apprehension has a predatory crime section that investigates these crimes and also commands the ICAC, or Internet Crimes Against Children Task Force, for the state of Minnesota. And we have been encountering certain situations where county attorneys have been unclear if they were the appropriate venue for charging out a particular case based on a variety of fact scenarios. And so this would just provide that clarification that the case can be charged in various jurisdictions that aligns with how we've traditionally done these cases. The second piece, as Senator Westlin outlined, was on-scene preview. Just to give the pragmatic aspects of what this does, to be clear, we have a search warrant to search these locations for child sexual abuse material. We have specialized digital evidence texts that come out with us. Given, just think in your own life, just the number of different digital media that you have with you day in, day out, this allows us to kind of whittle down the number of items that we will actually seize pursuant to that search warrant to bring them back to our accredited laboratory to do an examination and provide that clarification. There is some judges that have allowed this, there's others that haven't, so we're looking to clarify this in the law. There are some protective provisions that are outlined in the actual language related to this. The third item is that noted this year we've changed, and we were in front of your committee before, and prohibition of childlike sex dolls. I know this is a bit crass in front of this committee, but they're just like they sound like. These are anatomically correct children, infants that are sex dolls. They're designed to be anatomically correct, and we are finding them as we do in particular, our child sexual abuse material investigations. And so we've lowered the penalty in this particular instance to try to see if that would be less concern for some members in the other body that had this last year related to this, trying to move that forward. And then the last one is kind of the opposite. It's something in this language mirrors language that has been passed federally for duress related to human trafficking cases. I'll give you an example of how this happens. One case that we had not all that long ago, the trafficked victims that were being forced to engage in commercial sex acts, where the traffickers were forcing them to go out during the day, steal mail, do identity theft, various crimes, and if they did not do that, they would be abused, and it makes it more difficult when they are charged with some of those crimes then to be able to actually escape from the trafficker because of the criminal histories that they are. It would be an affirmative defense then in those situations that they committed those crimes at the behest of their trafficker, providing protections for those. There was bipartisan support of this bill nationally, and we used much of the language that was federal, so it would apply to state crimes as well, and I'd be happy to answer any questions for members of the committee.
Thank you, Superintendent Evans. Any questions or comments from members of the committee? Senator Kroon.
Thank you, Madam Chair. Page 3 of the bill, the legislative findings. Two-part question. One, are legislative findings any different than a purpose statement? And two, should we have legislative findings in a bill?
Mr. Chair.
Senator Croon.
Senator Croon.
Senator Westlin, answer the legislative findings provision first, or question first.
We almost got to this before he got back.
Oh.
I kid. I do understand that. I am aware of the fact that we often try to avoid purpose statements and legislative findings, but I don't know if Superintendent Evans would like to answer why that has been included in this particular bill.
Superintendent Evans, explain yourself.
Chair Latz and members of the committee, I don't know that I can explain myself because those provisions were inserted as we were working on this by the revisor's office. I do think that pieces that were related to this, what we're trying to outline in this as we were working through this together and trying to do this is obviously in this particular instance or this provision that it is related to pieces that the on-scene preview directing the judiciary branch in some respects that this is a permissible use under the particular search warrant. So I think the legislative findings in this particular matter, we're providing some context as to we are not trying to instruct judges as to what they should be doing when it comes to this, but it's for this limited purpose and why those provisions are there. But I am aware to the question to Senator Croon as to this is often not something that this legislature likes to do.
It kind of looks more like, it looks like more than just blah, blah, blah legislative findings. It looks a little more important for providing the context for the bill. So I don't know, I'm inclined to think it's a little more valuable in this particular context than in others, but open thoughts, Senator Croon.
Thank you, Mr. Chair. For the record, I don't disagree with any of the legislative findings, so however you want to handle it.
Okay, so noted. Senator Limmer, do you feel the same way?
I can explain that in 2 words, Mr. Chair. Ditto.
That's 2 words now.
Consanguinity.
But can you spell consanguinity? Section 2. Article 2. Section 2. So, Superintendent, in Article 2, Section 2 on page 6, there is no language similar to Article 3, Section 2, which has a definitions section, which is a bit more specific, in part by identifying minors. And that's really the issue that I'm a little bit concerned about in terms of modeling after. The reason it's in Section 3 is to provide a sense of protection, I guess, or some immunity, as I understand it. But it's not in it's not in the previous section on possession of. Maybe I can have counsel can explain it a little more clearly than I can, but the question will be, why is it in one provision and not in the other, or should it be in both?
Mr. Chairman, members, I think the issue is in Section 3, the 3 crimes require that the sex doll be essentially, that a minor was used in an actual minor was used in the creation of the doll. And in Section 2, those 2 crimes, it's not similarly limited. So there's an inconsistency between them, and I guess the question is that intentional?
Okay. That was much better worded than I was trying. Superintendent.
Chair Latz and members, that was intentional in this particular instance. And the reason being, and I do know that this has created some discussion in the past about this. In Section 3, it was because it was modeled after that particular individual and then outlines those from there. In Section 2, the reason there is not that similar language, these dolls are often sourced from foreign countries such as, in particular, Southeast Asia, and being able to identify in those particular instances the specific child that the doll was modeled after, we found to be prohibitive or, very difficult for us to ever be able to do. Therefore, we'd never be able to prove the elements of that crime, whereas it's slightly different provisions in that Article 3. But we do understand the question. It was a matter of, proof as we'd be looking forward to prove these particular crimes, but it was an intentional choice.
That makes sense to me. Any other questions or discussion? All right, so this is amended. Mr. Turner, do we have to be concerned about any fiscal impact here?
Yeah, Mr. Chairman, members, there's fiscal notes pending for both the Senate and the House files. I believe that this is probably going to need to go to finance.
So we could either lay it over and then, if it comes back with a positive fiscal note, send it to finance, or we could send it to finance now, and if it comes back with a positive fiscal note, as appears to be the process this year, finance can figure out what to do with it in terms of payment or coverage, or if not, it can go to the floor from there and not have to run through finance. Senator Westlin, do you have a preference on that as the chief author of the bill?
Yeah, Mr. Chair, why don't we just send it to finance and we'll see what happens?
All right. Senator Limmer.
Thank you, Mr. Chair. The previous comment I made regarding the findings, I don't want to appear flippant regarding this subject. Usually we frown on findings, and at least that's the Minnesota tradition. Other states do that all the time. But because this crime involves children and some of the more involved practices and the attempts to hide that crime from authorities, the finding really does outline very substantive factors that I think need to be emphasized. This is, I suppose this crime has always been around, but it seems to be taking on a significant proportion in our society, and I do believe it needs to be included in the legislation. I wanted to underline that. Thank you.
Any further discussion? Seeing none, Senator Westlin moves that Senate File 4292 be recommended to pass and be referred to the Senate Committee on Finance. All those in favor say aye.
Aye.
Opposed? Motion prevails. Okay, Superintendent, one more bill and then you are released from custody. Senate File 4371, Senator Clark.
Thank you, Chair.
What's our...
Chair Latz, Senate File 4371 is the BCA policy bill designed to make technical corrections and clarify existing statutory language. This one is focused on confidential funds reimbursement, peace officer record keeping, unsealing criminal history records, and vulnerable adult OFP dissemination. This bill clarifies legislative intent that reimbursements to local law enforcement for unanticipated long-term investigations are not subject to other granting requirements. It also updates language to reflect current practices and ensure that the BCA has the tools needed to effectively correct record errors related to expungements under the Clean Slate Act. And finally, this bill ensures that the BCA receives necessary information on orders for protection from the judicial branch to assist in effective enforcement of these orders. And of course, Superintendent Evans is here to provide even more information about the bill.
Superintendent Evans.
Thank you, Mr. Chair, members of the committee. Again, my name is Drew Evans, the Superintendent of the Minnesota Bureau of Criminal Apprehension. And as Senator Clark noted, this is a technical fix bill from our perspective in cleaning up some language related to Bureau operations. The first, as noted, we have a fund that you have in place that provides a couple of different functions, but one of those functions is to provide reimbursement to local law enforcement for various types of investigations, in particular, long-term unanticipated criminal investigations that are multi-jurisdictional. I'll give you an example that's related to this and where the challenge becomes with the language that we have in this is you'll recall the terrible case of a child that was killed in Anoka County that took months to find that child in a landfill earlier in the past year. During that time period, the Anoka County Sheriff's Office rang up a bill of $1 million+ in that obviously is unanticipated and onerous for them to fund. And so this fund is designed for those one-off cases to be able to soften the blow to counties and cities across Minnesota. The language in that particular provision right now says that it is a grant process. And as all of us in state government have worked to streamline our grant application processes, we have to go through a particular process that would follow a grant application process, but it really is a reimbursement of funds that they've expended. So the simply striking the word grant and changing it to reimbursement, all the same provisions in statute will still apply. The second is updating. If you look at the actual language, it's very dated. It goes back probably 50, 60 years talking about a peace officer must maintain records of particular crimes in their jurisdiction, but we've advanced. And the process that we now follow is called National Incident-Based Reporting System in Minnesota. The whole nation has adopted this standard, and so this makes changes to reflect the current practice of collecting crime data. The requirements are still there, but frankly, those requirements are upon the BCA that are put on the agency and reporting in, so they're covered that way. The third is providing a mechanism with the clean slate law. There was not put into the provisions that we missed in this process where there's a technical glitch or a programming glitch under clean slate where the record has already been sealed, that this would give us, without going in front of a judge to get a court order, we would be able to identify the record and unseal it when it's been identified as being erroneously sealed, where both the BCA and the courts agree that it should be unsealed. That would provide that provision. And lastly, you passed a provision in 2025 related to financial exploitation of vulnerable adults, a particular type of order for protection. This provides clarification in the law that those particular orders should be passed by the judicial branch to the BCA for dissemination to law enforcement to create consistency with other types of order for protection to provide that. As we analyze that particular language was not included in that, so it's treated differently than different types of orders for protection, and so it's providing that clarification to have those passed. And I'd be happy to answer any questions, Mr. Chair, members.
Members, any questions for the superintendent? I'm not seeing any. Senator Clark, any closing remarks?
No, sir.
Wise man. Where's it go? Is there any fiscal impact? Mr. Turner was so impacted, he's gone. Superintendent, do you believe there's any fiscal impact on this bill?
Mr. Chair, I do not believe there'll be any fiscal impact.
Straight to the floor. All right. Senator Clark moves that Senate File 4371 be recommended to pass and be sent to the Senate floor. All those in favor say aye.
Aye.
Opposed? Motion prevails. Thank you, Superintendent. Have a nice evening. Okay. Commissioner Schnell, would you like to join us? You've been waiting quite patiently, but you've got quite an agenda with us today as well. Senate File 4370 is before the committee. Senator Clark, if you'd like to go ahead when you're ready, let us know what this bill is about.
Thank you, Chair Latz.
Commissioner Schnell testify.
Thank you, Chair Latz. Senate File 4370 modernizes Minnesota's licensing system for juvenile facilities and halfway houses. Currently, these facilities operate under a half-century-old all-or-nothing licensing model. That is, if a facility falls short of standards, the DOC's only real option is full license revocation, a move that disrupts residents, staff, and our communities. And as a ethics and compliance professional, I can tell you that all or nothing is not the standard anymore. It's also degrees of being out of compliance and being able to be brought back in. And that's what this bill does. This bill fixes that, extending the graduated licensing tools already used for local adult correction facilities to juvenile facilities and halfway houses. It also ensures these facilities have the same rights to appeal and legal protections. Today, of course, we have Commissioner Chanel to walk us through the details of this bill.
Commissioner, welcome.
Thank you very much, Chair Latz, Senator Clark, members of the committee, Paul Schnell, Commissioner of Corrections. This bill makes a practical overdue update to Minnesota's licensing framework for juvenile facilities and halfway houses. In 2021, this committee passed the Hardell-Sherrill Act with bipartisan support, creating a graduated licensing tools for the DOC to use with local adult correctional facilities. Those tools allow the DOC to issue conditional licenses, require corrective action, and monitor progress toward compliance rather than immediately shutting down a facility. The law also created a clear and fair appeal process, but those same tools do not apply to juvenile facilities or halfway houses. Instead, they remain stuck in the outdated all-or-nothing model. A conditional license allows a facility to stay open while fixing deficiency, which promotes stability for youth, residents, and staff, while still holding the facilities accountable for needed changes. To be clear, this bill does not change jail licensing. This bill simply extends the proven graduated model to all DOC licensed facility types, creating consistency across the system. It also addresses a structural issue in statute. Provisions that apply only to state correctional facilities are embedded in section 241021, making it look like they apply to all facilities. That has caused some confusion for those who rely on the statute, facilities, regulators, and members of the public. This bill addresses the issue by relocating those state-only sections into more appropriate parts of the statute, making the law easier to understand. The Minnesota Juvenile Detention Association has been a strong and thoughtful partner in shaping this proposal, and I want to thank them for their meaningful engagement on this bill. This is a shared effort to create a licensing framework that is consistent and predictable. I want to thank Senator Clark and thank you, Mr. Chair, and members for your consideration, and I'm happy to stand for any questions.
Chair Latz, we do have
Senator Clark.
Thank you.
We have an author's amendment here, the A1, offered by Senator Clark. All those in favor say aye. Opposed? Motion prevails. The amendment is adopted. To the amended bill, any questions or discussion? Not seeing any discussion. Senator Clark, looks like it goes to state and local from here. Is that what you understand?
Yes, sir.
Senator Clark moves that Senate File 4370 as amended be recommended to pass and be re-referred to State and Local Government Committee. All those in favor say aye.
Aye.
Opposed? Motion prevails. Senator Holmstrom. Senator Holmstrom, we have Senate File 4265 in front of us. This is the first committee of jurisdiction. And we have an A1 amendment. That'd be an author's amendment. Senator Holmstrom moves adoption. No?
No.
You're not. All right. Tell us about your bill.
All right, thank you, Mr. Chair and members. This bill represents an important conversation to bring necessary clarity to our our statutes related to probation service delivery. I'm grateful to my colleagues and co-author Senator John Hoffman, as well as all the work this committee has done over the last several years to streamline and support a single funding formula that supports local decision-making in the delivery of critical, needed probation services. Shortly after I was elected, it was brought to my attention from community members and from commissioners that there remains some ambiguity in the statute addressing CCA. The key ambiguities include the benefit transfers and payouts due to the varied approaches in vacation and sick time or general paid time off, accrual transfers, and probationary status. As I worked to peel back the layer of this complex system and talked with other stakeholders, I also discovered that there could be better timelines identified for transitioning counties that outline an intent to change, a clear process for what information is required, and when opportunities for questions and supplemental documentation. So the outline of this bill is designed to provide a better framework and timeline for that notification, clarity as to what benefits actually transfer, and responsibility by entity for agreements that they make at either local or state level, and an appropriation to an account for those benefits assumed by the transition entity that are over an entity's capped benefit structure. You'll have a copy in your packets from key county stakeholders who support the important tenets this bill represents. That's the Association of Minnesota Counties, the Minnesota Intercounty Association, Minnesota Association of Community Corrections Act Counties, and Minnesota Association of County Probation Officers. Before I turn this over to my first testifier, I want to acknowledge that this bill has been brought many stakeholders to the table to discuss what works now and what needs modification, and what can be done in both the short and long term to improve the process and structures. That does include the Department of Corrections and Commissioner Schnell. I appreciate everyone's commitment to continue to work in this fashion to find language that addresses the key pressure points. Mr. Chair, my intention is to lay this bill over and upon this committee's indulgence, to give everyone a little bit more time to work through these things and bring this bill back at a later time.
All right, go ahead, sir. Go ahead and identify yourself for the record.
Mike McMillan, Director of Wright County Probation Department. Mr. Chair and members, been to you a couple times in this committee over my 40 years in criminal justice and probation. And super excited to be here and talk about continuing to move forward with all the progress that we've made in the criminal justice system, specifically in the probation realm. Minnesota relies heavily on community supervision as a central component to public safety. Most individuals in our correction system are supervised in the community. Making a strong, stable, and county-administered supervision system is essential to public safety and outcomes of our state. Over my time in this work, things have changed greatly. Some unbelievable milestones that have been supported by the legislature. Our court services tracking system, which is state-of-the-art, evidence-based practices, risk needs assessment, case planning, restorative justice, our organizations working together, I think, like very few states in the country. The Senator has mentioned a number of those. MICA, MACAC, AMC, MACPO have really come together over the years to make changes, including the Department of Corrections. So I'm super excited about that. As we continue the work, though, there's some things that always come up that need to evolve to make some changes to make it better. Senator has listed and talked a little bit about what this bill's about, and I think the changes will address some of those to even make us stronger as a criminal justice group and probation group across the state. So that being said, as we continue to work for this successful implementation between counties and the state, we have found some ambiguities, sorry about that, that we think deserve clarity. Ensuring employees impacted by transition between supervision delivery systems are treated fairly, maintaining salary, recognizing years of service, and critical to supporting workforce stability, retaining experienced staff, and ensuring continuity of that supervision services. The bill before you is structured to reinforce the principles employees should be made whole during transition, and responsibility for accrued leave benefit obligations appropriately remains with the employing entity where those benefits were earned. We believe the clarity is necessary in the statute to outline a process by which counties can exercise their statutory authority to change the delivery systems. Wright County, as an example, currently has been waiting for over 6 months for the department to acknowledge our local decision and aid in effective transition from state to county. We think this is too long and support efforts to find agreement on adding timelines and process in the statute. This is not shortchanging and not valuing the important work the probation does. In Wright County, as an example, we have the lowest turnover rate of any department in the county. We put a lot of value in our county does on our probation department and the work that they do. Above market value salaries, premier training programs, and leading the state in evidence-based practices with their support. In conclusion, we thank Senator Holmstrom, Senator Hoffman for moving this critical conversation forward. Thank you, Mr. Chair, and members for prioritizing the importance of getting this right, both for the state and the counties, and for the safety of our communities. Thank you.
Thank you for your testimony. Any questions or discussion from members of the committee for this testifier or on the bill? Sounds like all of the questions have been answered.
Thank you.
Senator Holmstrom, any final comments before we lay the bill over?
Yeah, I think that it's really good that the two parties are coming together on this. However, there are substantial problems that still need to be worked out. I look forward to hearing how those conversations go, and we'll bring this forward with an amendment to meet what seems like is a fair reconciliation. Thank you.
Thank you. I see Commissioner Schnell waited. Did you want to add something while we're on the record on this bill, or Devin Bruce? Go ahead and just identify yourself for the record.
Thank you, Mr. Chair and members. For the record, my name is Devin Bruce. I'm the Director of Legislative and Political Affairs for the Minnesota Association of Professional Employees, MAPE. They are the state probation agents that are being transferred from state service into county service, particularly in Wright County. And we represent over 18,000, mostly the DOC as well as in the MACPO counties. After years of the funding inequity, we came to an agreement back in 2022 to move forward with a single funding formula model that I think works well for both our counties, but that was also largely contingent on our employees that are transferring between the different delivery systems to be made whole. And what this bill does is actually not just shifts the burden of responsibility on the funding, which for us isn't necessarily the big issue. It's the accruals that we ensured that the employees that would transfer with them as they move between the delivery systems, which for our members go largely towards their severance package as well as their HSA when they retire from service, follow with them. We came into an agreement with MACAC, MACPO, with MICA, with AMC, with bill authors back in 2022. That language was reflected in the statute when it passed in 2023. And now this seems to be reversing some of that trend and depriving our members of their hard-earned benefit accruals. So we understand that there's going to be a lot of work and that conversations are still ongoing, and we'd appreciate this to continue, as well as some of the other conversation to get reconciled in the meantime.
Thank you, Mr. Bruce. Commissioner Schnell.
Thank you, Chair Latz, members of the committee. Paul Schnell again, Commissioner of Corrections. The department's concern with Senate File 4265 stem from a broader system-level issue affecting community supervision across the state. This is a complex issue that intersects employment law, collective bargaining, and intergovernmental relationships, and we recognize that there are places in statute where additional clarity would certainly be helpful. In 2023, following Justice Reinvestment Initiative, Minnesota adopted a new funding formula for community supervision. This reform was developed collaboratively by the department, counties, and many stakeholders, including labor. And it was represented the first significant increase in fundings for supervision in decades. Throughout that process, there was a shared understanding that a new funding structure could result in counties transitioning supervision between delivery models, particularly into the CCA model. Minnesota law has long required that when employees move between systems, they do so at the same grade and with the same benefits. That statutory framework was the starting point for the 2023 reforms, as was just described by Mr. Bruce. During the justice reinvestment process, additional protections were added to clarify expectations around such time as leave accruals. These protections were part of a broader agreement that allowed the reforms to advance. As counties have transitioned, practical and legal questions have emerged. Counties' questions about how to interpret benefits, how to reconcile differences between state and county compensation structures, and what obligations each system has when employees transfer. These issues are not unique to a single county. They are system-wide and affect all supervision models. There is ongoing litigation related to some of the questions at hand, and for that reason, the DOC cannot comment on the specifics in this particular case. More broadly, however, the DOC believes that the proposed legislation is premature. While the bill attempts to respond to real concerns, it does not fully account for the complexity of the statewide system or the importance of maintaining alignment among state and county partners. These challenges are best addressed through a coordinated system-wide review involving all stakeholders to identify operational, policy, and administrative solutions. Just yesterday, the DOC had productive conversation with county representatives. There appear to be a shared recognition that a more comprehensive and collaborative approach will be necessary, and we've certainly committed to continuing that work. We are also certainly willing to talk about the timelines that were mentioned. For these reasons, the DOC cannot support the bill as currently drafted. We appreciate the opportunity to be part of the discussion and remain committed to working toward a balanced and thoughtful solution. And thank you, Mr. Chair and members, and I'm happy to answer any questions.
Thank you, Commissioner Schnell. Any questions from members for Mr. Bruce or Commissioner Schnell? All right, thank you for the conversation and encourage the ongoing conversations as well. Senator Holmstrom, anything before we lay this over?
Yeah, I just want to point out the colorful relitigating of history that we just heard. This bill is looking specifically to address the responsibility for accrued benefits. Right now, the Department of Corrections is choosing to read the language that, read existing statute to determine that the county entering into CCA is responsible for the benefits accrued under state employment. We're not moving from one department to another. We're moving from one employer to another. And asking the counties to, or forcing them to take on that burden is reading a lot into the current statute. That is what this bill is attempting to do, is clarify the statute so moving forward, counties are not held hostage by this misread. I appreciate it.
Senate File 4265 is laid over. All right, members, our original plan was to go to 5:30, but technically our access to this room expires in 1 minute at 5 o'clock, so we're at a good breaking point in the agenda. So what we're going to do now is we're going to recess to return at 7:30 in our usual room over at the Capitol, G15. Members, put any paper that you wish to keep inside of your folders. Everything else will be recycled. The room will be closed after we recess so staff may secure the space. So please leave the room expeditiously. With that, members, thank you for all of your work so far today, and we will reconvene at 7:30 in G15. We are in recess.